Serial. One application file today, my lord, for implement in a matter listed tomorrow is item number 3 tomorrow start. This will be that tomorrow. Tomorrow. Hmm.
Okay, we'll take it as item one.
Great feature of justify effective also items for quoting for example your field from the cooperative department.
Yes.
We have got estate allocated. For a week of
You're saying the consent of the other side?
yes, yes,
Right. The German prayer has been made on behalf of Mr. S.K. Talukdar, Learned Counsel for the Cooperative Department. Uh, uh, who is the full for the petitioner? Miss, what's your name?
SP box.
S.
P box.
Your name is not P.
Vale.
Huh?
My name is not there, my God in the oh.
Yeah,
I will use
Mr.
the petitioner.
Mr.
I put
Okay, the petitioner counsel does not object to the same. This is a matter after the application. How? Today's 19. Yes, sir. This is the matter. Monday. Monday.
Applied.
yes. Guidance 33. There. I am not speaking that.
Okay, yes. That's what I was thought. Mr. A. Rashid, learned counsel for the petitioners, submits that the matter has become effective. According to who is appearing? Mr. P. Sharma. New tender, cancelling tender, that's right. The Mr. S.K. Roy appears for the, S.S. Roy appears for the, uh, for the state. The writ petition is accordingly dismissed as effective.
May I please?
Make it.
I am praying for
Yes,
I beg to mention item number 23 dot for
yes.
adjournment for a day.
Why?
Dr. My senior and this was out of state. I'm for the respondent number 5. I've taken consent from the day.
Okay, right. On the prayer for adjournment made on behalf of Mr. M. Biswas, counsel for the respondent number 5. This is the matter after
Closely,
after the vacation. Hello, it is in order to continue till the next day. Yes. Okay, right. On the prayer for adjournment made by Mr. P. Sharma, counsel for the AFDC. This is the matter after the vacation.
Lord, I'm praying for listing of an I, which is connected with item number 10 of tomorrow's list.
Tomorrow?
Yes. Public.
Item 22, I'm told that the instructions are awaited. Can it be approved?
Okay. Right, Mr. S.S. Roy, Learned Counsel for the State Respondent submits that he awaits instructions with regard to the dues payable to the petition. This is the matter after the vacation. Right.
I'm attending on behalf of yeah. So, keeping today's 6 items before we return for a serious constructive difficulties. Item number 4.
I know. Difficult matter. Excise matter. You want to lessen the amount.
You
I do not know. That it has gone to the, it has been, you have come here, this is the third time. Third time.
going to file for
Aye, aye, regarding this case, this is the motion. What aye? Whether you withdraw and I don't know, file a fresh or something. Anyway, right. When do you want?
Monday.
Monday. Right. On the prayer for a genuine made on behalf of Mr. S.C. because this is the matter of Monday. Full stop. The, the, it is noted that this matter has, so it is noted that the petitioner has approached its court for the third time, praying for lessening the penalty amount. Penalty amount and the license fee. Page 34 of the writ petition would also have to be gone in this. This is the matter of Monday. So you know where you are, and I know where I am, so that I can just. Yes.
Operating now favor.
That's why you are the judge.
No, absolutely not, because it's just one small opportunity for the day, because it's just make it any other day of favor. In fact, you're paying us the current salary or the current bill also.
Current bill, you have to pay.
No, but then 80,000 amount that has come up, we also that's a bona fide matter we are trying. Just a small part of it.
Right. A general prayer has been made on behalf of the petitioner. Petitioner's counsel. Who's for the AP this year?
I'm taking the.
Okay, Mr.
Take it, but
No, your name? Huh?
M. Sharma here.
Mr. M. Sharma.
Yes, sir.
Learned counsel for the petition submit that he has taken the consent of Mr. KP Pathak, learned counsel for the AP this year. According to English, this matter after the vacation. I think you want
I'll
that.
leave it to you, Lord. I'll leave it to you, Lord. In fact, there was a direction for them.
Huh?
There was a direction for them to also get what is such job report. That was also what is done. But these are like
Give it this, give it this.
this is some great report. Until then, you're not.
It's in order to continue till then.
May I please? So I'd like to mention for I understand motion. So what happened on the NIT issued by the MSc or Issue Autonomous Council already opened on yesterday.
Fishery.
Is it? Already NIT issued by the MSc wherein I am already in the settlement to
Settlement by the
By the state.
by the state.
state.
When?
That's 2 days. I am already filed on 40 days.
Today.
Today,
Tomorrow? Tomorrow? It's already open.
but,
Have they settled the fishery? Missing? No, I don't think.
I no information. But what happened?
Tomorrow. Okay, tomorrow. I'll take it up tomorrow.
Obliged.
Matter for listing that matter admission matter from Monday.
So regarding what?
Regarding content matters,
First matter, no hurry.
Madam, it's very urgent.
What is the urgency?
Madam, last 2-3 months it was not.
No, what is the issue?
Issue is it did not comply with the order of the
What is the order?
order is to verify the caste certificate and to issue the training fee as per law.
Caste certificate.
Yes, sir.
This is not a bench for matter. Caste certificate. Is it a bench for matter?
Yes, it is very important.
Caste certificate. Yes. A fishery. Oh, fishery.
No, very important, madam, not fishery caste certificate. Schedule caste.
Okay, Monday. Tuesday.
The content is matter. Right, maybe listed on.
Regarding what? What is the issue?
Non-payment of bill
Okay. What is the hurry?
pending this is last.
Last one. Yeah. Monday. Tuesday.
What is the specific period of the with the practice of the night? My name does not reflect that. My consent is taken for consent.
Okay, right. On the prayer for adjournment made on behalf of Mr. P. Bhadwaj. Then counsel for the petition. This is the matter. After, oh, where is Sharma, Mr. Sharma? No. This is the matter after the week.
My lord, I would like to mention the matter, writ petition 4749 2023. My lord, according to order dated 5 February 2024, the matter was supposed to be listed after 4 weeks, but the matter has not been put up. If you can just,
What is the matter about
it's in regard to government tender.
government tender?
Yes,
Okay.
much obliged, ma'am.
Yeah, here.
My lord, Gita Devi, there was season court number 1, was may I pray for the last. Okay. He was the thing.
What is the Okay, what's your name?
NX Lashkar.
Third, Mr. N.H. Laskar, learned counsel for the petitioner, who submits that the order dated 19/7/23, passed in WPC 6022 of 22 has not been complied with. Issue notice returnable in 4 weeks. Petitioner will take steps for service of notice upon the respondent by registered post AD within 3 days. This is a matter of the post.
May I fix a date?
First time it's coming, Mr. Counsel.
Lordship, I am informed by the largest pending of litigation that his matter will expire. Therefore, Mr. N. by that. But if this honorable court want to please to proceed the matter, then. If honorable court please to proceed with the matter.
No. Oh, why have you filed this writ petition? Are you intending to participate in the tender process or what?
No, this honorable court passed an order. Dated 15th of.
No, I understand. I've read the order. My question to you is, why have you filed the writ petition? Are you intending to participate in a tender?
No, I did not participate, but same tender who petition was already filed before this honorable court. Already filed.
So?
Since August 2020. But subsequently, I found that in those restrictions, that delegation of financial power is violated.
Mr. Counsel, what right of yours has been violated?
Can we go to the?
No, please understand the law. The Supreme Court has said, not me, the Supreme Court has said that to invoke the jurisdiction of a writ court, some right of yours has been violated. You are saying that there has been no delegation of powers by the chief engineer to the superintendent engineer. Now, if there is a delegation, if he doesn't have the power, by doing that, what right of yours has been violated?
Because this is related to earlier two cases. This is not a new case. This is related to earlier two cases which are already being filed. This is not the method with club. This is not a new restriction. It's not because in the.
Okay, right. Mr. P.K. Badakati, learned counsel appears for the petition in person appears. Full stop. It is submitted that the counsel for the respondent, Mr. Inufadia, is mother-in-law expired. Accordingly, the matter is adjourned for 2 weeks. Is the matter after the vacation. Next. I just said one thing. The petitioner would have to show as to how his rights have been violated. Yes, what is your case?
Lordship, in this case, as per your lordship's last order, I need to produce the government's decision.
Your Lordship, I would like to say that in this case, the approval of the government is not necessary because approval of the government is not necessary because the locations that already been approved by the government, thereafter tender takes place. And the retender are going to happen in the same location, not in a new location. Because and that
So you all have decided to retender the thing.
retender of person,
There was only one tenderer.
one tender.
But Act says lordship is the only state government's power to accept or reject. Lordship, I would like to take lordship to section 26 of the Assam Excise Act.
Yes, please read.
Lordship,
Yes.
section 26 2, lordship.
Yes.
The state government may at any time, if in their opinion it is so necessary, cancel any notice calling for tenders for settlement of stock in accordance with the rules framed under this act for any
Wait,
tender
which section?
received.
Which section?
Section 26 of the Assam Excise Act 2000. Lordship, may I apply?
No, this is not.
Page 4.
Page 90.
Section 26.
Yes. Yes.
Subsection 2, lordship. the state government may at any time, if in their opinion it is so necessary, cancel any notice calling for tenders for settlement of shops in accordance with the rules framed under this act, or any tender received in pursuance of any such notice, or withdraw any shop from settlement of for such period without assigning reason. Therefore, and such power of cancellation withdrawal shall be deemed to have been always been vested in the state government. Apart from this section, Lordship, I would like to take Lordship to Rule 114, Lordship, of the amended.
Yes.
Lordship, the amended rule of the 114,
Yes.
2023, Lordship.
Yes.
Um, 114 A Roman 14 laws, where there is only one tender for a shop. If the licensing authority is satisfied that tenderer is eligible for grant of license, that the statutory requirement have been fulfilled, he shall accept the initial grant bid offered by the applicant, may grant the license with previous approval of the state government after realizing the transfer. Provided if he is not satisfied, he may reject application after recording reasons therefore. So, Lordship, so the committee has to decide whether I'm eligible or not.
No, that is one. He can also reject for other reasons. It is not circumscribed. Sorry. You don't understand. You see, supposing they want to sell a building as big as this, say, or a license as big as this, and you give your bid of say rupees 1 rupee only. Supposing you are the sole bidder. Is it compulsory on the part or mandatory on the part of the government to accept your bid of 1 rupee just because you are eligible?
Lordship, that power is lies with the state government. I'm not on their lordship. If my offer is
Too less.
accept or reject,
uh.
the power lies with the state government. State government can do that, but not the committee, Lordship.
But not the committee.
Yes, Lord. The committee can, Lordship, evaluate my financial bid, whether I'm eligible or not. Technically, I'm qualified. Whether my financial bid is, if there is any effect.
So yes, so he is saying that the tender evaluation committee has taken a decision, which it is not authorized to do. It has to be done either by the state government or the licensing authority. The tender evaluation committee is not the licensing authority. That is it. So you're taking a decision.
Lordship, may I take a page 35, your Lordship? 35, clause 13, your Lordship.
And
Or tender document, Lordship.
Page
35.
Yes,
The rights of the district collector in regards of EBD, clause 13.
yes.
Notwithstanding anything contained in EBD, the district collector reserve the right to accept or reject any bid and to announce the selection process and reject all bids at any time without any liability or any obligation for such acceptance, rejections, or annulment, and without assigning any reasons thereof.
Let please first carry on.
The district collector reserves the right to reject any bid if at any time any misrepresentation is made or uncovered. The bidder does not provide within the time specified by district collector the supplementary information sought by district collector evaluating the bid. Such misrepresentation, misproper response may lead to disqualification of the bidders and forfeiture of this scheme.
I don't think it is correct.
And at page 13, your Lord.
No, tell me something. Has the bid of the petitioner been rejected by the district collector?
Yes, your Lord.
Where is that?
Because the DCs,
Where is that?
this page, your Lordship, at page 60, your Lordship. The e-bidding committee is headed by the DC, your Lord. E-bidding committee is headed by the DC.
It might be headed by the DC, but it is still the bidding committee only. It is not the DC.
The center approval of the government is required when there's an L1 bidder and we need to sanction for the license. That's when the approval is required for the government. But in case of tender, the locations are already approved, your Lordship. The locations are already approved by the government.
I'm not on that, Mr. Council. No, you are you are also reading the book with blinkers. Look, please come to the rules for settlement of shops at 26. Please read.
The state government may anytime, if in their opinion it is so necessary, cancel any notice calling for tenders for settlement of shop in accordance with the rules framed under this act, or any tender received in pursuit of any such notice, or withdraw any shop from settlement or for such period without any reason thereof, and such power of the cancellation or withdrawal shall be deemed to have
Now.
vested in the state government.
Now, Rule 26(2) clearly provides, that is section 26 to
26.
clearly provides that the state government can do it. Okay, no doubt about it. Out here, state government has not done it.
Not that.
Now let us go to the rules made in terms of the act. They amended,
They amended it.
yes, they amended it. 114A.
When there is only one tender for a shop, if the licensing authority is satisfied that a tender is eligible for grant of license and that the statutory requirement has been fulfilled, he shall accept the initial grant offered by the applicant and may grant the license with the previous approval of state government after realizing the applicable license fees and secure deposit. Provided that if he is not satisfied, he may reject the application after
So
recording.
out here, the licensing authority can reject. He can reject
He
the
can
tender.
reject.
If he is not satisfied regarding my eligibility.
No, not only
No,
that. You cannot, no, please, that will see. Wait. That is your interpretation. I do not think you can subscribe, you can limit the provisions of this thing to that aspect. Now out here, the licensing authority has not cancelled, it is not the case of the respondent that the licensing authority has rejected the bid of the petitioner.
Yeah.
So as per the act and the rule, they have not been done. It has only been done according to you in terms of the NIC.
Terms of it.
Now, these terms of the NIC, when there is a statutory law providing a certain authority to who has the power to reject or not accept a tender, can an authority made which is not in consonance with the act and the rules exercise that power?
You cannot do that.
Simple as that. Then you let the licensing authority take a decision. You take a decision, or the state government take a decision as to whether you accept it bid or not. Take a decision. End of the matter. What remains? Because as per I think that case. So what is that case?
One is okay.
Huh?
One is the one.
That is my order. That is Debendas.
Dependent.
In Debendas, what happened was I think there were three bidders. Two of them fell during the technical evaluation bid thing. And then then the government said that we want to have a retender, only one is there. He came to court. Court said no. His bid should be accepted. He has bypassed everything. But then he differentiated with a case where there was only one bidder from the very beginning. So his case fell. So even under Debendas, you have got no case. And out here, you have got no case because how much is your bid?
4 lakh.
4 lakh. And the neighboring thing is 36 lakh.
That is also lordship.
So
that committee also not
let the authority take a
lordship. Authority is state government.
state government can take, licensing authority also can take.
That's what the act is concerned. It's only lordship. Even the
But the rules also provide that. The rules also says. The rule says that he may reject the application.
lordship kindly come to lordship subsection 1 also lordship.
Subsection 1 of
Section 26, Lord.
Yes.
The excise commissioner, collector, or any officer or authority in issuing any license or in making any settlement of so under this act or rules when they are under shall be guided by such direction as may be issued by the state government from time to
Yes.
time. Either
where is the direction?
And again, Lordship, 3 also, Lordship. State government may issue direction to excise commissioner, collector, any officer, authority to cancel any notice in accordance with rules when they are under detect calling for
Anyway,
tender.
let the state government take a decision. End of the matter.
Let the government take it.
Mr. Right. Heard Mr. S.K. Singla, learned counsel for the petition. Also heard Mr. R.R. Gogoi, learned counsel for the excise department.
That's one of 1, 2, and 4.
That is response number 1 to answer. Mr. S. Roy appears for response number 3. That's all. Okay, then you take para, the last order, para 2, 3, 4, para 2, 3. Okay. Mr. R.R. Gogoi, Learned Counsel for the respondents number 1, 2, and 4. Submits that in terms of clause
Clause 13, Your Lord.
13 of the NIP, dated 9/2/2020. The district collector has the right to accept or reject any bid or to annul the selection process without assigning any reason. He submits that as the bid of the petitioner has been evaluated by the, where is that, by the, where is that? Evaluated by the
Page
Page
60.
60, Your Lordship.
16, 16,
60.
has been evaluated by the bid e-tender slash bid committee headed by the district commissioner, Kamakacha. The rejection of the petitioner's bid on the ground that his bid amount was very low compared to the neighboring shop. Neighboring shop was
No, neighboring lot, different location.
how does it matter? Was justified. I've heard the learned counsel for the party, counsel for the party. Section 26 of the Assam Excise Act 2000, hereinafter referred to as the Act. States as follows. A perusal of Section 26 bracket provides that the state government can cancel any tender received in pursuance to any tender notice or withdraw any shop, without assigning any reason. Next up. Rule, the amended Rule 114A, capital A, bracket 1, bracket Roman 14 of the Assam Excise bracket Amendment bracket close rule, 2026, hereinafter referred to as the amended rule, provides as follows. I'll put this again. A reading of the above rule, a reading of the above sub rule shows that where there is only one tender for a shop, and if the licensing authority is satisfied that the tender is eligible for grant of license and that the statutory requirements have been fulfilled, he shall accept the initial grant bid offered by the applicant and may grant license with the previous approval of the state government. However, The proviso to the said sub-rule provides that if the licensing authority is not satisfied, he may reject the offer made by the applicant after recording reasons therefore. Full stop. The sub-rule clearly provides that while grant of license would have to be made with the previous approval of the state government, if the tender is found eligible for grant of license and statutory requirements, the proviso does not put a limitation on the exercise of power by the licensing authority. Full stop. Licensing authority for rejection of our rejection of a tenderer's application for grant of license. Full stop. Next step. The Act and the amended rules having provided the authority who can reject the tender application, the rejection of the rejection of the petitioner's tender by the district magistrate, district commissioner, district commission. In terms of the NIT, does not appear to be in consonance with the act and the rules, with the act and the rules, act and the amended rules. Thus, this court is of the view that as there is a specific provision. No, instead of that, you're right. In the case of Tulsi Ram Patel versus Union of India, 2008, the Supreme Court has held that there must be a source of power for exercising the same. Full stop. In the present case, the Act and the amended rule clearly provide the source of power for the state government and the licensing authority to act upon the bids of tenderer. Full stop. As such, it would have to be the state government or the licensing authority who should take the decision as to whether the tender of the petitioner should be accepted or not. Consequently, as the state government has not taken a decision on the said issue, the who will take a decision? The respondent number one. The respondent number one is directly take the decision as to whether take a decision whether to accept the petitioner's tender in terms of section 25(2), 26(2) of the Act. The writ petition is accordingly disposed.
Lordship, item 26 and supplementary 41. Same.
Okay, just a minute. 26 and
Supplementary 41.
26. Then we'll have to put You put that two people will change it. Say the same paragraph you put in everyone. Give me 41 then. Because 41. You take that.
You have to place is in rural area, Lordship. There is
That's
only
the
difference.
difference.
Otherwise,
Yeah, you see, only in one it is rural area, in the other is called urban area.
Urban area.
So where,
Otherwise,
so where's the
if you know
question?
right, say.
Huh?
If you know right, say.
But then where's the impugned order? There's an impugned order.
That might,
The minutes, the
The
e-tender,
minutes.
the minutes.
Minutes of the tender committee. Yes.
oblige.
Public.
Has your other side come? Oh, then you have got to wait.
The matter is that non-payment of contractual dues, Lordship.
Okay.
At this stage, notice may be issued, Lordship.
No, how much have you completed? Only 35% of the contract work.
In 185%.
No, Mr. Council, in the present case,
In the present case, 35%.
35%. How much are you claiming?
Lordship, in the present case, Lordship,
2640, 26 lakhs.
Lordship.
Now, what is this FDR or what FD or what is this?
That was deposited at the time.
What is it? FDR or PDR or what is this?
Will be
What is this?
performance secure.
Performance security.
Lordship.
So beyond that 26 lakh, you are also claiming the
Lordship,
performance security.
Lordship.
Now, Mr. Council, you see, I do not know. Have you ever checked up the agreement made between the parties? You have not. You see, there usually in an agreement made between contractor and the government, there is a clause that if the petitioner is unable to do the work will be given to a third party, and whatever has to be borne will be paid from that amount. So you cannot just release also. You have got to ask for the agreement and see whether that clause is there. If that clause is there, then there's no question of paying it. Until and unless the entire work is done and there is some amount payable to him. Yeah, no, just you accept that.
But here, Lordship, we are hearing only for respondent number 1.
Is there any, where is the contract agreement? Huh? Not annex. Please annex. Please show us. Is there any clause which provides for completion of the work by a third party? And that the payment for completion of the work will be from this estimated amount.
That I have to take touch of regarding contract.
You have to get that. Right. Heard, Mr.
Keyboard letters.
P. Bordoloy, Learned Counsel for the petitioner, who submit that the petitioner was given the contract work of carrying, laying, testing and commissioning of a pipe network. Distribution of pipe network. Or distribution of pipe network under the Sibsagar water supply scheme. By modified work order dated 4/10/2019. So the contract is still subsisting or terminated?
Subsisting.
Subsisting. Oh, then they, okay, that's different. That's different. The petitioner cannot submit.
Recently, that kindly produced an extra 8 page 34, Lordship. By representation that I have submitted, Lordship, in the next second para, Lordship. Recently, we have come across the e-tender dated so and so issued by the Mission Director of Road Assam for execution of Sibsagar Town Water Supply Project. From perusal of the aforesaid e-tender dated, it is crystal clear that the existing work that has been awarded to the undersigned has also been included in the aforesaid e-tender along with other works, Lordship.
So what does it show? That your contract has been terminated.
That termination of it,
But that you have not challenged.
that
You have not challenged anything.
also not served.
It is not your case that your contract has been terminated.
Otherwise, let them take instruction. And I think the matter after vacation for the schedule supply. Let them take instructions or I think the matter after vacation.
You also
Lot,
take
lot, lot,
inspection.
lot, lot.
It's not one-way traffic.
Lot.
Problem is they're not getting inspections also. That's one thing. And then you're also not bringing everything to the court.
Lot.
What have I said? Though the petitioner has completed 35% of the contract work, the petitioner has not been paid his contractual dues amounting to rupees 26,40,991. He also submits that the petitioner should be refunded rupees 2,97,000 against the deposit made. With regard to the deposit made against the performance security. That means you have accepted. You have accepted the termination.
That's why he's asking for the performance.
Good stuff. Issue notice returnable in 4 weeks. Mr. SSY accepts notice on behalf of
Respondent number one.
point number 1. Which 2, 3, 4 who are they?
They have their separate planning of. Assam Urban Water Supply. MD, Assam Urban.
We do not know, so we have to you take steps.
Lot.
Petitioner takes steps for service of notice upon respondents number 2 to 4 by registered society within city. The prayer made by the petitioner really goes to show that the petitioner's work, no, it implies that, don't say clearly good. It implies that the petitioner's contract work has been terminated. However, the petitioner has not submitted or annexed the contract agreement made between the parties to show as to whether the petitioner is still eligible to receive the performance guarantee, performance security, and as to whether there is any clause in the contract agreement regarding completion of the remaining contract work by a third party and the mode of paying the bills of the third party. The letter dated 20/07/23 issued by the petitioner at page 35 also shows that e-tender dated 30/06/2023 has been issued against the existing contract work that has been undertaken by the petitioner. This is a matter of 4 weeks.
Same process, item number two.
Same,
Lot,
All-
that is 80%, 85% work.
same thing. The work order is the same.
No lot.
Yes.
Work order.
So out here, the work order dated 11/2/19. Okay. 11/2/19. Then wait, and out here the contract work is different also.
Lot.
Then what is thing same?
On payment.
Contract work is supplying, fitting, fixing, and commissioning with ISI mark. I think. Cannot be IS mark. Must be ISI mark. ISI mark cast iron pipe with flanged edge ended FLANGED ended and CI specials and valves, etc. With regard to the Sagar water town water supply. Then he has completed 85% of the work. Outstanding amount is 7,42,757. The fixed deposit is 69,000, 69,000.
And letter that is page 29 annex H.
Outage is the letter dated 20/07/23. Page 29. E-tender dated same, huh? E-tender of 2023. And so it shows that your contract has been terminated. Very clear.
Apply, sir.
I'm being 36.
Sir, I am waiting for instruction, also they are just preparing for it, because they are also studying. I'm already, RA has been completed.
Huh?
RA has been completed.
RN? What is RN?
Reverse option.
Huh?
Reverse option. Not what happened.
Reverse option.
What happened in this case, my lord? The technical evaluation of 3% has been not qualified. Now, my lord, they give time for RA, my lord, reverse option. My lord, if somebody, basically, my lord, it is a sort of negotiation. Say who can come down and all that or come up and like. So that was over, my lord, yesterday I told my lord that it was still.
It was too late anyway.
And also, also.
That is over, my lord, but this, my lord, this,
You see, one thing is, his case is basically, he was a proprietorship.
Yes, sir.
Now, he has given his tender in the form of a partnership. But all his account statements are in the form of proprietorship. So, his basic case is that the statement of accounts given by him should be read as the accounts of the partnership. So,
And it is
that's all.
rejected by lawsuit,
Huh?
by return or by lawsuit.
Huh?
It is rejected by, he submitted a representation in this respect. lawsuit.
Acha,
And it is
representation rejected.
representation they have refused to consider.
It is rejected.
Lord, my submission, my lord, will kindly see.
At page 10110.
110.
11.
Another
109, my lord, in lord, there is some.
Oh.
109. I'll read. ठीक है, ठीक. May I read it?
there.
The bidder has participated in the GM bid with bid specific authorization of so and so tendered. The original offer of the tender bid has been deliberated on the basis of GM bid condition and the offer submitted by them, and accordingly disqualification has been communicated. So that on 10/6 they have communicated. The bidder has submitted annual turnover certificate which was not found to be relevant for the bidder, and accordingly disqualification has been communicated to the bidder. Now the bidder along with their representation has submitted additional document. It is to be mentioned that instant bid has been published on ISNA and opened on 19/4. All the bidders were having an opportunity to submit their bid complete in all aspects as per the terms and conditions of the GM bid. In case after disqualification has been communicated to the bidder, they have submitted additional document. From the above, it is evident that the state submitted was not complete and was having shortfall documents which has been submitted by the bidder with the representation. Since the additional documents has been submitted by the bidder along with the representation which is after GM bid opening date, the additional document submitted by the bidder along with the representation is not considered by the tender committee. The bidder disqualification still stands good at this stage also. My lord, may I just my lord point out to my lord, the clause GM 1 and 3.
Huh?
GM 1.
You had all the time in the world to submit your clarification with regard to the bid submitted by you. Why didn't you make a clarification earlier?
I would like just to my lord to point out, my lord, that what was their condition, my lord, what I am required to submit. My lord, if your lordship kindly turn to page, my lord, 28 of the bid document.
Yes.
Page 20 of the bid document, the minimum average annual financial turnover of the bidder during the last 3 years ending 31st March of previous financial year should be as indicated above in the bid document. Documentary evidence in the form of certified, your lordship is certified audited balance sheet of the relevant period, or a certificate from the chartered accountant, post accountant indicating the turnover details of the relevant period shall be uploaded with the bid.
Lord, I was asked to, Lord, only upload either a certificate from the chartered accountant or post accountant, or, Lord, a certified audit bill. And, Lord, I have, Lord, uploaded the document along with the bill.
But you have uploaded the document showing that you are a proprietorship, but your application
The partnership.
was as a partnership firm.
I'll just show 2 minutes. That's the turnover. Page
No,
30
turnover is all right.
page 39.
Page 39.
So it was not mentioned anything there, my lord, that whether it is a turnover of the, my lord, partnership firm or
No,
it
but then it is understood that once you make a, once you make your tender, as whether it's as a company or as a partnership or as
Or
a
a LLP or-
proprietorship or as an individual, then your statement of accounts or your turnover certificate has to be in terms of that. Supposing a company is there, you can't give a proprietorship firm's turnover. Similarly,
my lord, your lordship will kindly see annexure 3 page 30.
you should have explained it in your very tender itself at the very beginning.
They could have submitted, true, my lord, your lordship is rightly saying that they should have submitted it.
Because your partnership firm was to take effect from 1st April.
Last April, it was executed on 14th, my lord.
Yes, but
It was
no, but
14th,
your
14th.
partnership
Yes,
firm, the conveyance deed says that
Ah.
from 1/4 everything should be as a partnership.
Because till 31st, they have, my lord, worked as a proprietorship firm. Because
Maybe,
in the meantime, father expired
maybe,
and all
but
that.
then you could have clarified easily.
My lord, they asked only the, my lord, turnover document. My lord, they have not asked any other document along with that.
But you should have clarified that this is
My lord,
your-
then, my lord, your lordship will kindly see in the bid document, 2 days time is there for clarification. They have not sought for any clarification. No 2 days time was given to us, my lord. My entire grievance is that.
No, but then they have replied to your representation.
Yes.
They have, then, my
They
lord,
have submitted
after
it
they,
Page 109 is the reply.
after they disqualified me on 10/6, then on 11, I submitted a representation along with this document.
Also, they have
They say that since we have already disqualified you, and since you have not submitted this document along with your bid document, so this additional document cannot be considered at this stage. That is it. My submission, my lord, that can be considered. Your lordship knows, my lord, the New Horizons case and all that.
No, I don't.
My lord, in that, my lord, the question of credentials and experience. In para 26, the Supreme Court was dealing with the joint venture. Said that, my lord, a man may not have an experience, my lord, he has entered into a partnership. The partners are there, partners may have the experience. Even partners' experience can be counted for the purpose of the, my lord, partnership who is participating in the bid document.
That is a different issue. Out here, so you are a partnership. You're a partnership, and
Now, my lord, your
the proprietor has expired.
proprietor expired, my lord, but my lord, can you see the deeds, my lord? There are the recitals in the deed very clearly said that, my lord, it will be a continuing, my lord, business.
this date is not submitted last
No, not submitted. This, I am
No, it
also
is
saying
not
not
with the tender.
tender document we have not submitted, my lord. I am saying, my lord, it is not a, my lord, thing that should be suppressed, my lord. My lord, that can be considered at this stage also, my lord. Very difficult.
Lordship, after opening of the bid, lordship, they cannot lordship.
No, if your
No,
lord,
no. Where is the explanation? This is the explanation.
Huh?
This is the explanation to the
The lord-
109 is the reply to the is the decision on the petitioner's representation. Is it?
yes, yes. That is, my lord, they have communicated me on 14/6, my lord. And then, my lord, then I approach this on the.
You take a decision on his petitioner's representation. You are saying you have not considered. You consider and take a decision. It
Yes.
can be rejection. It can be
No, no,
allowed.
that is up to them, my lord.
That
Already
That is-
the process is over, lordship, and
is over.
if it is, lordship considers their claim at this stage, lordship, the third person right will be,
Lord,
lordship,
my lord,
affected.
No. What has happened? Has the work order been issued?
Work order not issued,
Then-
lordship, but other process is already upward.
Lord,
It will be
permitted to
issued
say,
in short later.
may permitted to say, reverse auction has been, yesterday it has been closed. Now, my lord, the entire matter will place before the tender committee. Chamber committee will ultimately finalize that whose financial bid has to be accepted. That has not done as yet. And thereafter only, my lord, question of work order and other things will come. So, my lord, at this stage also, my lord, no third party right has been created. And in this connection, my lord, my submission is that, my lord, let them consider my representation. Whatever they say, if they say that no, it is not acceptable, my lord, let them reject it. My
Okay, it is
satisfaction will be
already
there.
rejected and lordship,
It is already rejected.
already rejected lordship. After
No,
the-
no, but madam, please read. It's very easy for you to say rejected. Please come to page 109. Please read the second last line.
additional documents submitted by the bidder along with the representation is not considered.
Is
by the
not
SAP
considered.
or not considered.
So what does it mean? Is not considered means what? It is not considered. You have to consider it because you have given 2 days time to make a representation, to make a clarification of the issue. So he has made a clarification within the 2 day time period.
Yes.
So he makes a clarification as per your terms and conditions. And you say, no, I will not consider.
No, it is considered not,
Then the use of the word is wrong.
nothing,
You see, you cannot better what is already written here. Supreme Court has said that. Correct. This is a document by the authority, not by you, madam. They have said not considered. Who are you to say they have considered?
not considered, the reason has been given to us, why it is not considered. It is not that they have not considered it or, it is considered logic, but the reason on, what.
Sorry,
it-
sorry,
the
I am
accepted logic.
sorry that you see, it has, then let them say that it has been considered, but it is rejected. Let them say that.
You are actually one of the document.
Along with the representation is not considered. My lord,
Logic, it is considered, it is not that, it is not considered, it is considered but not accepted, but the word is that it is not considered.
additional documents submitted by the bidder along with representation is not.
Yes.
So the additional documents are not considered.
There is additional documents were submitted after the opening of the bid, and therefore it was not accepted. This is the case of it. It is not that it is not considered at all or the, yes. Yes. And since all the process has already been completed and other bidders have already selected or whatever may be. Yes. And in that case, not with other, the other bidders whose bid has also been rejected on some other grounds, they will also place the same benefit.
Why not?
After opening of
If they've got a legitimate ground, why not?
process, there is no.
They have not come before, they have not approached this. I think they have not agreed.
From the above, it is evident that the bid submitted were not complete, was having shortfall in documents.
But my submission for that melody, you are asking for only one document. I'm giving that document.
No, but then that is also not a, you see, one thing is that you are a partnership firm. You cannot give the account statement of a proprietorship firm, which belongs to your father, not to you. In the proprietorship, none of your names are there. It is your father.
Father.
Then what is wrong?
Not saying,
What is wrong that way?
and my lord, your lordship will kindly see the recitals. The lordship has already gone into, my lord, I know, my lord.
Already
That,
expired.
yes.
These are all new.
You should have
but-
clarified in the very beginning, at the time of thing.
It is also not an expert,
All those clarifications were not given in your tender.
Verification, my lord,
Published on the now the bidder submitted additional information that the initiative has been bid was on 22 March, opened on 19/4. 19/4.
It is discussed with the rejection orders. They have got enough time to process.
19/4. What was the technical bid was opened or financial?
evaluation,
Huh?
of technical related.
Technical. And financial on
was opened, my lord, as far as we know, my lord, on 15/6. After rejection,
on 15/6. 15/6 is 15/6 is Saturday. Huh?
exact
Saturday.
date, I do not know, my lord.
That is what you are saying. When was the financial bid opened?
Process, I am waiting for the instruction project.
But,
It
my
is
lord,
not-
You're waiting for instructions?
Yes, sir.
page 114, if you're not finding page 114,
Huh?
2 p.m. expected.
page 114,
Look, yes, right.
last
Yes,
page of
yes,
the.
right.
RA started, reverse auction started on 15/6.
Reverse auction started on 15/6.
That is document I have given as an extra 8 million.
Reverse auction started 15/6.
Yes, my lord. And
Yesterday you were saying reverse auction started today.
no, yes, sir. No, I have not said, no, I have said,
You said-
no, I said, no, it will finish, no, today at 6 p.m. it will be open. 18th will be open. Your lordship will kindly see here it is. RA end time 18/6/2024, 60.
Okay. Anyway, right. Heard Mr. K. Karwa, senior counsel for the petition, assisted by Mr. K. Karwa. Also heard Ms. R. Devi for
Okay.
others. The petitioner's grievance. Now, the petitioner's prayer is for a direction to be issued to the respondent to consider the petitioner's representation tax clarification dated 11/6/2024 as uploaded in the GEM portal on 14/6/24. No, 11/6/24. And to set aside the refusal to consider the petitioner's representation slash clarification, which was uploaded in the GM portal on 14/6/24. With regard to the issue of the petitioner's bid having been disqualified, financial bid having been disqualified,
Technical,
Huh?
technical.
technical bid being disqualified. The petitioner's case in brief is that the petitioner participated, the petitioner, which is a partnership firm consisting of two brothers and their mother, participated in a NIT dated, participated in a NIT dated 22/3/2024 and with corrigendum dated 30/03/2024 issued by the respondent number 2 for supply of 42,000 meters of cable. One of the conditions of the bid one of the conditions to participate in the bid in the bidding process for the said tender was that the prospective tender was to have an average annual turnover of more than rupees 10 crores in the last 3 financial years, ending 31/3/2024. 2024.
No, they say that 3 years, sir.
3 years means till 2024.
They have not given any end, 3 years.
Okay, don't say that. Last 3 financial. Next paragraph.
31st March of
Last 3 years.
financial,
And ending 31st March.
31st March of previous financial year.
That means 23.
Yes.
31/3/20. The petitioners counsel submit that the MS Supply Syndicate was initially a proprietorship firm in the name of their father, that is the late Ramator Jalan, Ramautar Jalan, who expired on 17/1/2020. Pusta. Prior to the death of the late Ramator Jalan, a deed of partnership had been executed on 1/11/2023, which consisted of the late Ramator Jalan and the petitioner number 2 and no, the number 2 and 3. By converting the aforesaid proprietary business into a partnership business. The said deed was duly notarized on 4/11/2023 by deed instrument number 09. However, the deed of partnership dated 1/11/23 could not be given effect. After the death of the late Ramator Jalan on 17/1/2024, the aforesaid partnership was reconstituted and a deed of partnership was executed on 14/2/2024. Inducting the petitioner number 1, that is the wife of the late Ramator Jalan, into the partnership. I will say, just read that last paragraph, the last sentence. Was reconstituted on 14/2/2024. And a deed of uh, a deed of declaration was also executed on 1/4/2024, where it was specifically declared that the partnership firm shall resume the running of the business of the proprietary concern with all assets and liabilities as a going concern after the close of business on 31/3/2024. Next part. As stated earlier, next part. Those after you. The petitioner thereafter submitted his bid as a partnership firm pursuant to the NIT dated 22/3/2022. However, the however, as the NIT requires prospective bidders to show that they had the average annual turnover of rupees of more than rupees 10 crores per annum for the last 3 financial years. The petitioner partnership firm, the petitioners who submitted, the petitioner submitted the financial turnover of the proprietary firm of MS Assam Supply Syndicate. The petitioner's bid was the petitioner's bid was thereafter rejected by the respondent at the technical bid evaluation stage.
Page 78. Page 78.
Page 78.
30, communication.
And the same was communicated to the petitioner on 10/6/2020. The reason for rejection of the petitioner's bid was that the petitioners had participated as a partnership firm in the tendering process. However, the turnover details that had been submitted were of a proprietary firm. They were accordingly not found technically suitable or eligible for opening their financial bid. Next, the petitioner's counsel submits that the GM portal was kept open for 48 hours, that is till 12/6/2024, for facilitating the bidders to submit their clarifications and slash or to make representation, if any, with regard to the technical evaluation done by the respondent. The petitioner uploaded their representation slash clarification along with some documents. However, the same was rejected by the respondent on 14/6/2024, as displayed in the GM portal. Next slide. The petitioner's counsel submits that the rejection of the petitioner's representation dated 11/6/24 is reflected in the GM portal, wherein it has been stated that the petitioner's representation has not been considered by the tender committee. And as such, the petitioner's disqualification remains the same. The petitioner's counsel submits that a direction should be issued to the respondent to consider the petitioner's representation slash clarification dated 11/6/2020. He further submits that the Disqualification of the petitioner's technical evaluation, technical bid on 10/6/2024, and the rejection of the petitioner's representation / clarification dated 11/6/2024, as shown in the GM portal on 14/6/2024, should be settled. Next up. Miss R. Davis, the learned counsel for the respondent, submits that subsequent to the disqualification of the petitioner's technical bid, the respondents have initiated the reverse auction with the remaining valid bidders, which has ended last night, which has ended on 17, 18/6/2020. At 6 p.m. It further submit that the petitioner's representation dated 11/6/2024 was considered by the authority, and the rejection of the petitioner's representation on 14/6/2024 clearly shows that the additional document that the petitioner had submitted along with his representation had not been considered. However, the representation per se had been considered by the respondent.
It was considered, but lordship, since it was not submitted before.
Okay, what have I said? Hannah had been rejected on the ground that the same had not been submitted by the petitioner along with their bid document.
After opening of the.
So
bid,
she accordingly submit that the additional documents that were a part of the petitioner's representation dated 11/6/2020 could not be taken into account after the technical bid evaluation stage had been crossed. They accordingly submit that there has been a consideration of the petitioner's representation. And the words used by the respondent, though confusing, clearly shows that the petitioner's representation had been successful.
Second order is.
She also submits that the rejection of the petitioner's technical bid is a reasonable order, as the petitioner had participated as a partnership firm while giving the turnover of a proprietorship firm, as the bid as the NIT requires. The as required proof of turnover of the bidder. I have heard the learned counsel for the the proprietorship firm of MS Assam Supply Syndicate was in the name of the late Ramatau Jalan, Ramautar. None of the petitioners here were the proprietor of MS Assam Supply Syndicate at any point of time. The petitioners were no the MS Assam Supply Syndicate became a partnership firm consisting of the three petitioners hearing. When the deed of partnership was reconstituted on 14/2/2024, after the death of the late Ramatau Jalan on 17/1/2024. The as stated earlier, the NIT requires the bidder to have average annual turnover of more than ₹10 crores for the last 3 financial years. The petitioner, however, submitted the annual turnover, the annual turnover of the proprietorship firm without making any clarification as to why they had submitted the turnover of a proprietorship firm in their bid document. The petitioner's technical bid had been rejected on the ground of having submitted the annual turnover details of a proprietorship firm, while the petitioners had participated as a partnership. The representation dated 11/6/2024 issued by the petition. The page where they are clarification,
It's 79. 79.
giving the reason for submitting the annual turnover of MS Assam Supply Syndicate as a proprietary firm. Was not accepted by the authorities. No, whatever accept, no, whatever accept. I will take it up later, huh? Basically, I'll pass an order. Let me see. I'll dispose it off. It'll either be dismissed or sent for consideration. I don't know. I'll just think.
No documents regarding change of proprietorship from in partnership of.
Not even, huh?
No documents regarding the change of partnership proprietorship of
Into partnership firm was given.
submitted lordship.
The ground
the
is not
time of-
experience and all that. The ground is on turnover. My lord will kindly consider. Now they come with something else, that can.
No, but then, we see, one thing is this. You are participating as a partnership
True,
firm.
sir, that's true.
You cannot give turnover of a proprietorship firm. It's say something like this. Supposing a proprietorship firm gives you participate as a company. Can you give a turnover of an individual?
So that,
So similar out here also. I don't know. You tell.
And also, Lordship, the partnership firm was constituted after the date of.
that facts are already.
Anyway, I will see.
I have not suppressed any fact.
No, that much I know.
Yeah.
You can't suppress.
Yeah,
You
right.
can't suppress any fact. Only, no, you see, their issue is you have brought out all these issues only after
So, man,
your bid was disqualified. Their case is you should have brought out all these facts prior to the bid
should have
evaluation
considered.
stage.
But my submission to that only, my lord, that they wanted only the turnover document, no other document. I have not given, no clarification.
I
as
said,
required. I have
just
not-
write one in the petition council submit. That the only requirement of the respondent in their NIT was the, no, one of the requirements was the submission of annual turnover of the prospective bidders
certificate.
without clarifying whether it should be annual turnover of a partnership firm or a proprietorship.
And they only asked for a certificate from the chartered accountant. No detail was asked. Certificate was already given.
Anyway,
And another aspect of the matter, just my lord, we pass on that order. My lord, there is a condition here also, my lord. Now, 3 participants are remained. Now, the condition is that, my lord, it can be the entire work can be split in four parts also. That your lordship will kindly consider it page 27. And 3 are already there. So, my lord, even if my, tender, if the representation is considered and will accept it, so far technical bid is concerned, my lord, there will be no difficulty. If your lordship kindly look at page 27, my lord. The split applied.
No,
maximum
but
number of bidders.
that is not our job, no. Whether you split or not
No,
split.
that is not, my lord, your lordship will not decide definitely, because that is their part. But my lord, their argument is that, my lord, only the third party right will be, my lord, affected and all that. On that I am saying, nothing.
But our-
Anyway, my lord, I leave to my lord. I leave to my lord. I'll give the decision of my lord.
Yes.
Two decisions. In fact, our high court is I could not lay the hand without our high court having one decision in this regard, but I could not lay. There is a decision of my lord. New Horizon Limited, New Horizons Limited, another 1995 1 STC 478. And my lord, another
Paragraph.
Para
Paragraph.
23 basically.
Huh?
Para 23. Well, there it has been said, my lord, for an example, because it was a case of joint venture. It says that let us assume that a person participated as a partner. Now, my lord, all the partners, this is a new firm. They don't have any experience, but one of the partner or the 2 of the partners were having the experience of this. So their experience also we can take into consideration.
Correct. That's a different issue.
I'm drawing an analogy from there.
But then if you're drawing the analogy that way, you were never a part of the you were never a proprietor.
But my lord, look, in proprietorship firm, my lord, maybe there, my lord, but ultimately there, your
No,
lord,
A proprietor and the individual, how do you differentiate between them?
my lord, your lord.
A company and a joint venture is different thing.
It very specifically states. It very specifically states, my lord, that they have grown up, they are participating in the, my lord, day-to-day business. So it is better that we should bring them as a partner, my lord. Your lordship, in the 11 January, the deed is there, my lord. Very specifically in the recitality.
No, if that is with regard to partnership.
I mean, lord, one of the decisions from the Allahabad High Court, where the question of not tender, my lord, because regarding some benefit to be, my lord, accrued and all that. in that respect, my lord will kindly see.
Para?
So this is not numbered as para. My lord will find in the second page last part.
Yes.
The same principle is applicable in instances admitted the undertaking was in existence in 2002. The proprietorship functions change into partnership. The benefit under section 81B of the Act is available to the partnership firm and conditions imposed under so and so does not come in the way. In Commissioner so and so revision measure, this court has held that exemption granted to the proprietorship firm which converted from a proprietor to a partner concern which still entitled for exemption under section 10A of the Act.
Very different.
Also notice the scope of decision review is very limited in the contract methodology. There is a different method. So this development is not available in the style of
Because there is a clarification of it. We have already made a statement to that effect.
Corrigendum.
Manual for procurement of goods by the Ministry of Finance and Department of Expenditure. 7.35, I have already quoted there, my lord. They say that, my lord, if it is not a new document, because turnover was already given. Historical document or any sort for, my lord, can be asked for by the tender committee. Not in para.
No, it can be asked for by the tender committee. They have got a lot of powers. As per the law,
I'm not saying that they don't have any discretion and all that.
they have a loose play with the joint. They can do that.
Whether in the facts and circumstances of the case, whether may not, they should have, my lord. Not for a clarification or not. No, that is the only, my lord, the question. In my humble submission, my lord, having they found this is the position, you could have asked for a clarification that if you have anything you shortfall, you kindly supply to us. I have quoted that.
Actually, it was their duty to clarify lordship, and there was enough time, almost 1 month lordship to clarify all these facts. And this was lordship also discussed in the rejection house.
And there was no pre-bid. With this respect, no pre-bid meetings and other things were there. Your lordship, I have already quoted in para.
Yes, that's all.
Para. There are 13 million, I have quoted that portion. 7.3.5 from that thing.
Okay.
Or, as far as the time of 2 days, in paragraph 12, I have made a statement. So they have not given it. But the authority must be fair, after all, it's state liability. True, that I have not given the document at the time of the meeting, but they are asking only for the declaration. I have given the declaration.
So also access of the proprietorship firm has been taken as they have submitted, but it is completely a new entity of the partnership firm because the other proprietor who was the proprietor is not part of this partnership firm. Totally new.
Is a partnership firm and a proprietorship firm the same?
They don't have any legal entity.
Huh?
Like company or LLP and all that, they don't have any legal entity. It says, there are 3-4 Supreme Court decisions. In fact, in my book also here, but I have not brought. It says that, earlier in proprietorship, the ownership is only on the sole person. When it is a partnership firm, all the 3 persons will be the owner. 2003, I think, 2000. A partnership is not distinct legal entity, and the partnership property belongs to all the partnership constituting the firm. That is 1980 Supreme Court 176, and then another decision.
One thing you're right. Just one thing you're right. Ms. R. Davis submit that the petitioner did not submit any document showing that the proprietorship had been converted into a partnership firm.
Eight feature lot.
What is the phase?
Lordship, this is a tender matter, railway tender.
Tender,
The ground of rejection is here in page number 53 yours.
53.
53 yours. 53.
Yeah.
Here, your lordship, here in the page number annex D, the rejection was list of works in progress for bid capacity evaluation not certified by third party.
So where is this required in the tender notice?
Because in the tender form, only it is mentioned. May I
Yes,
take-
where?
May I take your lordship, page number 25?
Yes,
Page number, may I read your lordship?
yes, yes.
The submitted details for 1 and 2 above should be duly verified by chartered accountant. So this 1 and 2 is on the previous page, your lordship, at page number 24.
Yeah.
Here below, it is mentioned, the maximum value of construction works executed and payment received in any one of the previous 3 financial years or the current financial up to date of inviting tender for circulating A and 2 existing commitments of balance amount of ongoing work with tender as per the prescribed performance of railway for statement of all works in progress and also the work which are awarded to tender but yet not started up to the date of inviting of tender for circulating B. In case of no works in hand, the nil statement should be furnished. I will read further of your lordship. The submitted details for 1 and 2 above to be duly verified by chartered accountant. In case if a bidder is JV means joint venture, the tenderer, within bracket as tenderers, must furnish the details of 1, maximum value of, it is same, like the previous A which I've read, same, this is the reason why, and during the tender forms.
Is it same?
Now, your lordship, may I take your lordship at page number 15? This was the document we have submitted according to the askings of the in the tender form. The technical bid was, we received the information late, recently, 14 of this month. Financial bid was opened on the same month. Now, 15, 16, 17 was a holiday, your lordship. So 18 yesterday we filed before this honorable court, and it came as an unlisted bidder before it, your lordship. But because of the paucity of time, now it is listed. So within the frame of the,
What is wrong with this decision?
we have submitted at the time of this one participation, we have submitted this at page number. 15.
Certified by chartered accountant.
Yes, it is verified.
They have said not certified by chartered accountant. It's a question of fact then.
No, it is certified. It's certified, your lordship. We have
We do not know. That's
what we have
a
approached
question.
this honorable court.
That's a question of fact.
Now, yesterday, your lordship, the work order is issued, your lord. Is issued. I think if it is issued, your lord, it is same with the outcome of the subsequent of the outcome of the writ petition. My earnest figure. But here we are coming before your lordship only because of the we are pressing that we have submitted. Because of the season confidence that we are, your lordship, we know the requirement and tender form is very transparent, your lord. Tender form is very transparent. So we know what we should submit. But he was a great.
Who is the railways? Who is standing for railways? Why is the railways council not present? Yesterday also not present. Today also. Who is appearing for the railways? Huh?
I think also it was not routed to someone.
Notice goes over.
No, I will give.
You see, his case is this.
Only that one, you know, only 50.
That that certificate. He says that it was certified by chartered accountant. His bid was rejected on the ground that it was not certified by chartered. So that is the only case.
That is the only case.
Only one thing, Mr. Counsel.
Highly obliged.
Besides that. Yours is a joint venture company.
Yes, a virtue of the memorandum of association we have done, particularly for this.
No, please listen. Now, this writ petition is filed by whom?
I have the locus, one
Huh?
of the partners of the joint venture. I have the locus.
Yes, you come to the affidavit filed by you. Page 14. It is not filed on behalf of the joint venture company.
Because I have the local share.
Where does it say that you have filed it on behalf of the joint venture? Where is that? Where is the averment that you have filed it on behalf of the joint venture?
That's why
You might be affected.
independently, I have filed your.
Independently, you have filed it as proprietor of Sandeep Kedia, not as part of the joint venture. You took part in the tender process
Yes.
as a joint venture, so that you would have the qualification to participate. As an individual, you did not have.
Yes.
Then,
But now as a agreed party, I can.
no, you're not in a agreed party. The agreed party is a joint venture. Where is your affidavit? Your affidavit does not say that you have come, you have come representing the joint venture. Where is that?
I have annex and it's a amendment over it.
No, you might have any,
Case number 31.
might have annexed anything. Where is your vermin that you have come on behalf of the joint venture?
Affidavit might not show you what, but since I have the focus, I have a procedure on the for the ends of justice.
Yes, you obtained this is, can you bring the report just to show that whether it's certified or not? That's all, end of the matter. It's a small issue. I don't know. Yep. Right. Heard, mister?
My name is Ian Ardari.
A. Nazari, Learned Counsel for the petitioner. To submit that the petitioner, that the petitioners and MP Sitani and Sons, represented by its proportioner Sri Aditya Sitani, executed a memorandum of understanding whereby MP Sitani and Sons and the petitioner's proprietorship firm entered into a joint venture in the name of MPS and SLK JV. Inverted comma. Super. The joint venture was made for the sole purpose of participating in the tender notice dated
In the page number 37, your lordship. Here, page number 37, your lordship. The closing date time is mentioned in 14/3/2024.
Tender notice,
Date is,
tender notice number
number is there.
LMG ENGG 24 2020. The petitioner's counsel submits that in terms of the tender form, comma, the prospective bidders were to submit a list of works in progress for bid capacity evaluation. Duly verified by chartered accountant. Page 24/25. Right. However, though the petitioner submitted his list of work verified and certified by a chartered accountant from, no, don't say though the petitioner, though the joint venture submitted a list of work in progress, duly certified and verified by a chartered accountant, comma. The petitioner's bid was rejected on 14/6/2024 on the ground that his list of work in progress for bid capacity evaluation was not certified by chartered accountant. Bracket page 53. Next one. Issue notice. Or what? You will bring the record or what? Okay, this record will suffice. Mr. S.S. Roy, appearing for the railway, submits that he will bring the record to verify as to whether the list of works in progress for bid capacity evaluation submitted by the joint venture that what is that name? MPS and SLK JV, inverted comma, was certified by a chartered accountant or not. The above being said, it is noticed that the writ petition has not been filed by the joint venture, by the startup joint venture, but only by one party. Who is having 49% share of interest as participant in the joint venture. There is nothing stated in the affidavit that the writ petition has been filed on behalf of the joint venture. This is the matter. When can you bring?
24th Monday.
Okay, this is the matter on Monday.
My humble brother. The work order is yesterday. Let the same be the subsequent.
This is a section of fact. Once it is there, then we see. 24.
Highly of
You see, I don't think they'll make a mistake. If they make a mistake, then we'll correct it. We'll set aside everything.
prayers.
Yeah, okay, just say one thing. Yeah, but I don't think there's a section of fact. I don't. I think you're free.
Highly of it.
Picture number 1 is Kalia Kushai Than Committee. That is Than Committee, and the number 2 and 3 are the president Chief Secretary of the State. Well, since the year 1946, this Than Committee is settling one market, that is Birwa Daily Bazaar, which is situated within their own land. This Than has 3 acres of land allotted by the government, and the bazaar is situated within their land, and they are settling this bazaar to some persons or NGOs, and by the income derived from thereby, they meet up the expenditures of this Than. But suddenly, the government by kindly see page 13 has issued, this is, sorry, page 15, has issued a NIT inviting tenders for different huts and bazaars. And our bazaar is serial number 21. Page 15, serial number 21, bottom. So the day has been fixed on 26, 24. That means tomorrow at 3 p.m. in presence of tenderers and other or their representatives. Now, my lord, if this bazaar is allotted by the government, that is Anchalik Pasad of Lahori Ghat, then the Than Committee will have no money and it will be difficult to run the same.
Do you have approval of the government to run a bazaar?
My lord, I kindly say we are doing this since the year 1946. An allotment order is there, my lord. Land allotment order is there.
No,
Next,
that's okay, accepted. Supposing we accept everything that you say.
kindly say page 29.
No, we accept everything that you say. You are running the market, it is your land. Now, what does the law say for the state of Assam? Can a person run a private market without approval of the government? Can it be done?
Approval is not necessary. Government cannot issue the subsidy. There are so many cases, and here some examples are also here available. Kindly see page 16, my lord. It is in Garlicular, my lord. You would know. Page 16, bottom. মহামান্য গুয়াহাটি উচ্চ ন্যায়ালয় চলে থাকা গোচরের পরিপ্রেক্ষিত
Page 16, bottom.
পেজ 16 বটম কাছারিবাড়ি চারিয়ালি দৈনিক বাজার গড়াইমারি চারিয়ালি দৈনিক বাজার গড়াইমারি শান্তিপুর দৈনিক বাজার নিবিদা স্থগিত রাখা হয়েছে। That means this is kept in abeyance all the tenders of these markets as per the order of the Honorable High Court. There are so many cases filed, and those are in those petitions. The order has been kept in abeyance.
Okay, they cannot run so they should not run it also. But you also cannot, how can you run a bazaar in a private land?
It's admitted, my lord, that it cannot run in a private land. That is also correct. But that this was issued on 29/5. On the last day, my lord, they are coming in with open.
No, that is written.
They may have approached the authority.
But no, we
Whether
Have you gone to the authorities or you
Yes,
come here?
You have approached the authority, but they refused to take any representation. The lordship may kindly see.
Because, my lord, as per the Samabandi, they have annexed, only 3 acres of lands are there. Including their, the Than, my lord, the religious purpose, and the market as per them. So within 3 acres of land, this cannot be possible, my lord.
I
No, there may
I
be
don't
some
know,
of-
maybe a small market.
Maybe, my lord.
I don't
No, I want.
Bazaar is a small bazaar.
Small,
That is
yeah,
not
yeah.
within. Typical land is allotted to in the name of Than. Bazaar is situated within a small area. That is
No, you see, it can be easily decided. One thing is that, who will verify whether it is.
Sir, my lord, but
That's
Central is not a party.
No, you answer it concerning the way.
Cannot murder the land.
Is it, who has issued the land document?
Can you see page 19?
No, who has issued the land document? Who has issued the certificate that you have annexed here?
That one thing.
No, please, Mr. Counsel, please do not, please, I'm asking you a question. If you don't want to answer my question, I know how to dispose of this case. Please answer my question. Please do not divert. who has issued you the 3 bighas of land?
The government.
Government. Then the government in the name of who?
Normally, this
Huh?
is
As per the page 30, the orders are of circle.
Circle office. Then let the circle officer take a decision.
that is not a disputed fact. That is not disputed fact.
No,
think
you see, we will let the circle officer take a decision whether this Giora market is within this Jamabandi here. If it is within this three, if he takes a decision that it is within this area, then till then the NIT should not be acted upon. And if it is found that it is within that area in the Jamabandi, then we'll direct the government not to act upon the NIT. That's all. End of the matter. What more do you want?
NIT has been issued by Ansalik Merchant.
Whatever. We'll tell the Ansalik Merchant.
NIT
Huh?
will not help anything, the petitioner also. Because they will also not get anything during this period.
You see, the thing is,
We can issue the settlement, subject to the outcome of the circle officer. That can be done.
what settlement?
Anyone, my lord, succeeded to that settlement, my lord. We may settle him, my lord.
No.
Subject to the.
No. If it is their land, who are you to settle there?
That we
That-
cannot.
You cannot do that.
They
So
have to
the-
satisfy, my
So
lord.
the
that-
circle officer will take a decision as to whether he is the owner of the land. If he is the owner of the land, then you cannot
Yes, that is
settle it
correct
with
also, my
anybody.
lord.
That's all.
Yes.
Because that is the only issue right now. The issue of whether he can run the market and all is not a
I'm just
issue.
thinking, my lord, that the market is a public thing, my lord. Public will suffer. That is.
Public suffers, that is a different thing.
Otherwise, we don't have any.
No. The only thing is whether it is his land or not. If it is his land, then you cannot issue
That
the
is a
NIT.
direct question of law.
That's all.
But 107 says, my lord, they have to take permission.
So
from-
that is, we don't know, we will not go into that issue.
Fine.
Because that is not an issue in this petition. The issue in this petition is only, it is his land,
NIT within private.
private land,
That cannot.
and that cannot be.
That cannot.
So let the circle officer, you submit a representation to the circle officer or to the DC,
Circle of law.
to the circle officer, and will direct because he is not here as a party. You have
That-
to
that-
maybe a party. No. Is the DC a party at least?
No, my lord.
Here it is not. The land is not disputed. That is why we do not.
No, but you see, to allow your writ petition, that clarification with regard to whose land is it has to be made. Now, I cannot decide, neither can you decide, neither you decide. It has to be made by the circle officer.
My lord,
No, the problem is you have not made them a party. That's the problem.
why dispute is there, my
Now,
lord?
how can I give a direction to a person who has not been made a party? So what you can do, Mr. Mahmood, just a suggestion. You withdraw this writ petition, file a fresh by tomorrow, add that circle officer as a party. We'll dispose it off, we direct that circle officer verify whether this Guera market is within the land of the petitioner. If it is within the land of the petitioner, the respondent cannot act upon the NIT insofar as Guera's market is in.
Not to, the letter part not to kindly dispose of the matter, but neutral may bring a dog with the after that. The circle officer will verify and thereafter he found it is within order, that may be calculated.
Without a party, my lord, they cannot file.
It's not a party.
Party,
Now, if he doesn't do it,
We are
how will you file contempt?
we are under 226, but that's
No, no.
already power.
No. It's a count. I know my limitation. I'm not.
It was earlier expected, that is that matter expected.
You see, as per the earlier method, I could have impeached him, but now there's a notification by the High Court. Unless there is an application for amendment, and you file an amended petition, then only it can be done. So that will take too much time.
That will take time.
That will take too much time. We're going to file twice. Instead of that, you withdraw this, you just add him somewhere here. And then you file the same thing once again, end of the matter.
Well, say, even in London corporation, but where to the authorities are not, don't settle this.
We are going to open tomorrow at 3 p.m.
Tomorrow, yeah.
Before that, they will have a.
You
order.
file it, You file it tomorrow morning, 10 o'clock, 10:30, we will take it.
By today, they can file.
Huh?
By today, they can file. 12:30.
Yeah, you file it today.
If we file tomorrow, then can list it.
You make a prayer. Yeah, that's the only way out. Otherwise, I don't see, nothing can be done. This will be never decided.
Because some land is disputes are there because, my lord, they are saying it's their land. Video issued NIT thinking that it's a government. So,
So the circle officer will decide that
Yes,
it is their factory. If it is their land, then you cannot do anything. That's all.
we cannot.
Mr. M.U. Mahmood, Land Council for the petitioners submit that he may be allowed to withdraw the writ petition with liberty to file a petition. Prayer allowed. Acha, Mr. S. Datta appears for the PNRD. Prayer allowed. The writ petition dismissed as withdrawn, with liberty of petition.
All right.
Here, your book. Mister, what is your name?
Conrad Goel Lordship, new income tax.
No, you incumbent is Akash Deep. What is your name? As a counsel. Mr. J.U. Ahmed, Learned Counsel for the applicant, submits that Mr. Akash Deep, IAS, Principal Secretary, BTC Kokrajhar, should be implemented as respondent number 4. Ms. R.B. Bora, appearing for respondent number 3, submits that she has got no objection in to the same. Shri Akash Deep, IAS, Principal Secretary, BTC Kokrajhar, is accordingly implemented as respondent number 4. Applicant to submit amended cost title before the registry, to the registry within 3 days. Okay, wait 3 days. Then you write in the main case, in view of the order dated 19/6/2024, passed in IA Civil 1827/2024, Shri Akash Deep, IAS, Principal Secretary, BTC Kokrajhar, has been included as respondent number 4. Issue notice to the respondent number 4. Petitioner takes steps for service of notice upon respondent number 4 by a registered post with AD within 3 days. This is the matter of proposal.
Simple order, there is
Huh?
specific order. There is a specific order allotted to second time amendment petition.
Huh?
This is second time amendment petition.
So what to do? They're transferring. If they transfer 100 times, you're going to make 100 times. What to do?
Similar.
Same. Then out here only the IA number will be 1836 of 2020.
But your lordship can produce the order dated 2024.
2/2/22.
2022. So the it was directed. So the circle officer was directed to file an affidavit as well as the respond number 5 the facility file. Because the report of the circle officer is contrary to what he has stated in the affidavit. But they have filed one affidavit on 4/4. That is by respond number 5, not by the circle. But the
What is the issue here?
issue is, we are challenging the jurisdiction of the respond number 5 in leasing out the public pond. In revenue record and everywhere, it is a public pond. Now they say that it is a fish shit farm. They have named it as fish shit farm, but the name of the pond is Aurora Rajoha Borpukul. It is a public pond, and in the revenue record also it is as a public. So we have challenged the jurisdiction.
So public pond is to be used as what? As just for. It should remain like that.
For the village,
No fishing allowed.
and they are now letting out for a commercial fish. We have challenged the jurisdiction on the ground that this pond, as per land revenue regulation, a notification has to be issued by the deputy commissioner for taking.
So who has to file affidavit?
Not the circle of.
But we have filed 5 as 5. Yes, my lord, as per order, you can.
Then when is he filing or do we ask him to file again?
Uh,
Meet you the Learned Council for the correspondence.
Well,
Submit that the point number 5 may be granted. How much time?
question number 5 is 5. That's
Five.
cycle of.
I mean, the submit that the circle officer may be granted. How much time?
3 weeks time.
3 weeks time to file affidavit. You know, to file affidavit in terms of the order dated.
Wait,
2/20. This is out. This is the matter. Anything else?
Like it maybe.
This is the matter after the vacation. Interim order to continue till the next week. Huh? 3 weeks. 3 weeks
Okay.
time. Sir.
apply.
Yes. Anything? Huh?
But this matter can be in fact closed. What I have
What is their contention? They are not position, but they are saying revenue to us. That's what my just now I think it. I forgot to find the FPD because it is my fault.
So, no,
This is of
so,
the
so
year
there's no,
2021, my lord.
huh?
I was.
They are in position and they are taking giving revenue also.
Who is in position?
My lord, I am in position.
So,
So actually the his main contention is that we have not given position to him. We are demanding, we are giving, we are giving a cancellation notice also. So I have just saying it, I forgot to find the application of my fault. It means some time. Actually, they are in position and they are giving revenue also. It is in his favor, Lord. It is in his favor.
I have no objection. I was only making sufficient that
Only
it can be closed because for the fact that I have been settled in 2021 and I'm continuing. In between, my lord, there was a small issue that they were demanding some illegal, my lord, demand from me by saying that I was a defaulter, which they have kept in abeyance. They are not acting upon that, and they are allowing me to continue with the revenue and with the possession of the features. So more or less, my grievances has been redressed, my lord. So rather than
you withdraw with liberty to file a fresh.
visual can say that perhaps if they do not again come out with it again the defaulted,
No, he said he's not going to come out.
but that of course I do not. So this is a
Yeah,
difficult-
as informed by my department Lord, it is in his favor, Lord. But I don't have any written documents, so I don't want to take the risk, Lord. Personally.
on which subject to my lord.
But even he can, it is in his favor. They are in position, they are giving revenue regularly.
Then what remains? What remains?
Yes, my lord. My submission lordship can always close this matter.
Lordship,
Or
recording that
he
they are
can-
in position
or
and giving the
If
revenue.
he wants to bring some written instruction, my lord,
And it is also.
What about the defaulter notice? What to do with that?
That important note, actually, that for my instruction, hardware instruction lot, that instruction was given by the project manager lot, it was not from the MP. So it is not, everything is in his favor lot. He's running the fishery, he's giving revenue regularly, everything is.
So he's not a defaulter.
At present, they're paying.
So he's not a defaulter.
No.
It doesn't matter. Correct.
Correct, but I don't want to take risk. He's also saying that he's paying.
Okay, you file, huh?
He's also saying that he's paying regularly.
there is no dispute to decide that, my lord,
Okay,
that I am
right.
paying revenue.
Third, Mr. H. Viragwahit, Learned Counsel for the petitioner. And Mr. P. Sharma, Learned Standing Counsel, AFDC. Ms. Yudas appears for the point number 6. 1, 2, and 6. No, AFDC. One per. The present writ petition has been filed on account of the petitioner being aggrieved by a defaulter notice dated 8/11/2021, demanding an amount of rupees 11,32,650 from the petitioner. today, Mr. P. Sharma. No, this is today. This is no.
My submission.
Okay, there will be Mr. Buragohain, H. Buragohain, submit that at present, there is no demand being made by the respondent for the amount of rupees 11,32,650. And the entire settlement of the fishery and the possession of the fishery in its entirety has been handed over to the petitioner. The petitioner is also paying his money regularly. So, as such, it appears that as on date, there is no grievance of the petition against the respondent. He accordingly feels that he may be allowed to withdraw the writ petition with liberty to file a petition. Huh?
Whenever faith was
Come on, whenever fresh cause of action. No, don't say that. We file a petition, that's all. That defaulter might still be there. You all might break it up. Then you say this is not a fresh cause of action.
Okay, Lord, no, I'm not against that.
Yeah.
Department is
Mr. P. Sharma submits upon instructions that the petitioner has been given possession of the fishery and he is paying his money regularly. He also submits that he does not have any objection to the prayer made by the petitioner's counsel. What, you want that? No, cut that. The last sentence you cut. Next, on considering the submissions made by the counsel for the party, the prayer of the writ petition is allowed. The writ petition is accordingly dismissed as withdrawn, with liberty to file a fresh.
and matter the board which dispose of. If,
Okay, instead of dismiss, you say dispose of.
highly open. If
Yes. Any affidavit
No, the instruction is
or instructed?
analogous methods are already been disposed of.
Analogous is a different issue.
It's claiming for payment of 126 Indian individual victims allotment. But
126?
he's claiming payment of 126 work which he has done. It's individual IHHL work. Individual household after he's paying 126. As per our record, with eligible payment of only 88.
Okay. So you challenge the rest. Will the order? Yes, according to you, you have done 126. 126 low cost individual household laptings. That's what you have according to you. Now, according to the respondent, you have constructed only, you are eligible for payment of only 88 numbers.
per amount is 12.
Mr. Council, have you understood what I'm saying? No, please look this side. Please look this side. No. You have said that you have constructed 126 latrines. Correct? State government is saying you are eligible for payment of only 88 latrines. That means your claim for 15 lakhs 12,000 will be lessened because they have not admitted to the entire 15 lakh 12,000 on the ground that they have completed only 88 latrines. So if you are still aggrieved for the remaining 38 latrines, you will have to go to the civil court. Okay. Anything? Any submission you want to make? Sometime for what? Sometime for what? For what? It is very clear. You see, in a writ court, we are only deciding cases where there's admission of facts. Facts are admitted. If there is a dispute with regard to facts, evidence has to be recorded, which is not usually done in a writ court. For evidence to be recorded, you have got to go to the civil court. So you go to the civil court. He does. I don't think we are on the same page. We are on the same page. I explained it for around 2 minutes. You explained it in 5 seconds. Cannot be. You must have said, just say yes. That's all. It cannot be. Okay, right. Third, Mr.
8J
A.
8J Tamuli.
A.J. Tamuli. Learned counsel for the petition. Also heard Mr. R.R. Gogoi for the Public Health Engineering Department.
Record number 1, 2,
From our respondents
four,
number
five,
1,
six, and
2, 4, 5, 6, and 7. Good stuff. Miss, you that appears for the respondent number 3. The case of the petitioner, a non-government organization, is that the respondent number 7 had issued 2 orders dated 3/8/17 and 19/8/17, for construction of 50 and 60, 50 and 76 numbers of low-cost individual household latrines, respectively. The latrines were to be constructed at a cost of rupees 12,000 each, correct? 12,000 each, under the Sashwa Bharat mission. The petitioner's grievance is that though he had executed the construction of 126 latrines and submitted his final bill dated 3/10/2017 and 22/12/2017 for the amount of rupees 6 lakhs and 9,12,000 respectively, the respondents have not paid him his contractual dues amounting to rupees 15,12,000 till date. Next para. Mr. R.R. Gogoi, the learned counsel for the PhD department, has submitted letter dated 14/3/2024, issued by the Chief Engineer, bracket PhD Sanitation, Assam, addressed to Shri P.N. Goswami, the additional AG Assam. Additional AG, Standing Council PhD, with parawise reply to the present case. So, present case, full stop. In reply to para 7 of the writ petition, the parawise comment states that the claim made by the writ petitioner is not found correct as per office record. The writ petitioner is eligible for payment of 88 numbers of individual household latrines out of 126 numbers. Pusta. The contents, the relevant paragraph of the parawise reply is reproduced herein below as follows. You take in red, para 7. Next, in view of the admission made by the chief engineer PhD, sanitation, Assam, that the petitioner is eligible for payment of 88 numbers of individual household latrines out of 126 numbers claimed by the petitioner, the respondents are bound to pay the petitioner his contractual dues for 88 numbers of individual household latrines. The chief engineer, chief engineer, bracket, respondent number 2 is accordingly directed to compute the amount payable to the petitioner for 88 numbers of individual household latrines and pay the admitted amount to the petitioner within a period of
The verification.
verification will take how long? Very, very smart. No time limit for verification, only for payment. For verification, how much time? Within a period of 6 weeks. Within a period of 6 weeks. From the date of receipt of a copy of this order. Full stop. Next paragraph. In view of the respondents having admitted the claim of the petitioner to the extent of 88 individual household latrines against the petitioner's claim against 126 latrines, the petitioner is given the liberty to approach the civil court for making his claim against the remaining work done by him as per law. The writ petition is accordingly disposed of. Before disposal of, we just say the letter dated 14/3/2024 issued by the respondent number 2 and the parawise comment annexed thereto are made a part of the record and marked as Annexure X collectively. The writ petition is accordingly disposed. Today is 19th.
Item number 31 and 30 also same, my lord.
But has he got the parawise comment? He needs, let him get the instruction.
Lord.
Now you can speak. I thought you could speak. That means you understood everything. That means you understood everything. Anyway. Just a minute. Item 32 and 31 and okay, let him take time then. Mr. R.R. Gogoi is granted a further 3 weeks time to obtain instruction. With regard to the claim for payment of dues made by the petitioner. List the matter, give a date. When do you want? 23rd July. Item 30,
31 and 30.
31 and 30.
They have entered into settlement agreement.
Oh, very good.
The only difficulty is that one of the signatory is extremely unwell and
Is unwell.
unwell. So we could not sign the settlement agreement. He has moved to Delhi. He's coming back.
When?
In 10 days, he'll be coming back.
The agreements are ready. On the last occasion also the same thing was free. I have drafted the agreement, I have sent to them. Maybe it's the baby, that's not problem. Actually, I'm not bothering.
Aged and
The only thing is that let the matter come up on 26th or 27th. And by then, my party is ready to sign. One of the signatories, there are two parties. One from the petition and two from the parties. So he is there, my petitioner is.
You all have agreed to the arbitrator also?
So we are not agreeing, they are not going for a arbitration, they are going for a settlement.
Okay, go for the settlement.
And these parties are going to pay us. That was a settlement.
it's all ready. Everything is ready just because Manuel has moved to Delhi. They are
Please move to
getting-
Delhi. Why don't you send the the agreement to Delhi and then come back?
That's what actually they are planning. That was I was told in the book. The rest of the partners will sign it today or tomorrow. The other ones they will.
Okay, right. Mr.
R. Sinha. For the
G. Dattatreya.
Star Sinha for the petitioner and Mr.
G. Dattatreya.
G?
G. Dattatreya.
G. Datta Stray.
Dattatreya.
Whatever. That is what I mean. Also for the respondent submit that the agreement has been prepared. However, the respondent is unwell and unable to sign at the moment. They submit that the matter may be listed on.
27.
Are you sure?
Yeah.
Then you have got to file it before 27 or 27 will give it.
not 27, this we can produce. Even if not before on 27. Because my party is ready to sign it today. One of the party is not able to.
So we can dispose it on 27.
Yes.
Okay, this is the matter on 27. Oh, it's already 1 o'clock. Item number
16 note.
16.
I have my consent of the other parties also. I have to file APDP note.
Yes.
So here. 16 note.
16, officially. Bid was rejected.
Not here, not I was rejected on some technical ground, a very flimsy ground in fact, that in the previous settlement, I was offered the settlement, I could not take it because I did not sign the agreement. So for for non-signing of an agreement, I was rejected subsequently on the second NIT, saying that I am technically not qualified because I did not sign the first NIT, wherein I was given this agreement for the same case. The interim prayer was rejected. And that was very small issue matter, and that ground is of course flimsy because it has no nexus with the earlier.
Now what to do? He's asking for things.
Second thing, I have to.
You have to file affidavit. Mr. P. Sharma is granted.
After the after the
2 weeks time to file affidavit in a position. This is the matter after the case.
They have paid for it.
We were did.
I'm high.
Apply that.
Sorry for taking the things, but another second.
No, it's done. No, it's done with it. Mr. Varala, counsel for the GMC, submits that he has received instruction. And you need further instruction.
Verification, because there are many technical things that will come.
Okay. And he needs clarifications on those instructions. Praise the Lord, this is the matter. Mr. Vora is granted 4 weeks time. to file affidavit in a position. This is the matter after the vacation, interim order passed early, shall continue to the next.
Since the plan of the petitioner expired after the investigator.
Who expired? Petition, husband of petitioner number 1.
Petitioner number 1 husband. He died in a.
The one who died is the husband.
Yes.
Don't say petitioner number 1. Husband of the petitioner number 1.
Yes. And my lord.
And who is number 2?
Number 2 is son.
Son. So what is to be done here?
The lordship consider their affidavit filed by respondent bringing on record the
Yes, what have you got to say?
I'm taking on behalf of the petitioner, respondent number 125. Number 6 is filed an affidavit. I want a copy.
You don't have a copy.
Then only we will, I will be able to obtain it. I submitted another phase for the technical report matter. In the subsequent judgment of our, can be disposed of their, is entitled is for proposal.
Where is your senior? Who is the senior?
Each was very nice.
Huh?
Each was big.
Why can't he appear?
He's having a severe toothache.
Today, he was here. He wasn't here today. Huh? Right.
So we will file our affidavit matter. Just we need copy of this instruction. We will obtain instruction.
Instruction from whom? That is chief electrical report. So you give him a report. Mr. W. Ahmed appearing for the respondent number 1 to 5. Submits that affidavit and position will be filed as soon as they have given a copy of the report made by the chief electrical inspector. So that means you have not put the affidavit of the respondent number 6. Yes, Mr. S. Roy, give them a copy. Mr. S. Roy, learned counsel for the respondents number 1 to respondent number 6. Shall furnish a copy of the affidavit filed by the respondent number 6 to Mr. W. Ahmed within the course of the day. This is the matter after the vacation.
Can it be on?
18.
Okay. I think. This the details of the farmers is fine. Petitioners have completed their B.Pharma from RKDF University Farm. That's an affiliate to Pharmacy Council of India. After that, you have applied for licenses, paying the requisite.
Yes, who is for the health department?
Dr. Brahman, Dr. We received the instructions saying that they are preparing the parawise comments regarding this particular case. Dr. In this instance, they are 2 weeks time.
The lordship is very language.
Lordship may take a note of it.
You received you are preparing parawise for
Yes, but they are preparing for parawise.
health department. Let them prepare. Okay, Mr. M. Bhuya appearing for the health department. That means that the health department is preparing the parawise comment. And accordingly, it's time to file the affidavit. So, Ms. A. Jayan, DGC submits first. That means that she needs time to file affidavit with the police. For which time is granted, this is the matter.
Last location lordship है तो अनुपात से मानो directive to take instruction आया था everything instruction
हाँ?
I have to receive instruction.
Whatever is they found, my lord, I am eligible that can.
No. Not so. I heard Mr. J. Barbuya, learned counsel for the petitioner, who submits that the petitioner has not been paid the vehicle hire charges amounting to rupees
46 lakh 6,450.
46, 06,25. Issue notice returnable in 4 weeks.
Notice already been issued.
No notice instruction as a
Notice issue. Acha.
The admission.
Oh, this admission.
Yes.
And then receive Miss Yudas submit that she has not received instructions till date. She is accordingly granted 2 weeks time to 3 weeks time to obtain instructions and file affidavit on behalf of the respondents number 2 and 7.
my lord.
Yes, madam, you're there.
For
Acha, you're for 2 and 7. Acha, then Miss Yudas is for whom?
my lord, I'm for my lord 1, 3, 4, 5, and 6, 8, 9, 10.
Ah.
But the deputy
Then Miss H. Barwa appearing on behalf of the P. Nayak, counsel for the respondent number 2 and 7, is also granted 3 weeks time to obtain instructions and file affidavit, if necessary. This is the matter after the meeting.
Nice.
I would like to profit of time.
Would you like to?
Profit for time.
Yeah?
The petitioner license for airfare from. Department 23 55. Down. Then they were under
855.
55.
Yes?
The following paragraphs of legal agent of government stated communication, rather than an immediate have been submitted as they were the system perfectly related. The relationship of the division and they were tagged with the on identity of the great. Mobile. Not it down. In the order two. That the authority can cancel the license file, the somewhat convicted by the court. And more minor, but the suspension cannot be accepted beyond minor 90 days, 3 months. And minor affidavit has been filed by the authority. They have said that they will be there as the honorable court.
But the CM vigilance case is still pending against the application. So that's why my lord, since matter is my lord,
Same beginning, what is it? What is, with regard to what?
my lord, their shop my lord, because they are regarding my lord.
No, what was the case against
distribution,
them?
my lord. This-
Huh?
My lord, against the my lord, the dealer, my lord. not against us, and the official. When it got and it's the FIR, the allegation, my lord.
You were in the judicial custody.
Yes.
You were given bail.
Bail.
Where is the bail order?
Page 39.
Yes.
Just ordered. I, my lord. So the page 46, my lord. So, second para. It was the it was answer to the first, into the approach was possible. I believe to be. And my lord. The police. The picture number 1, he was also reading from page. That is page 6.
How many petitioners are here in this petition?
4. That they have not initiated any action against us.
My lord, because
in this case.
proceeding is pending, my lord, because that same detained lordship will find at page 33 of your my lord, page 33, my lord, that this is the my lord, allegation regarding my lord, misappropriation, my lord.
No, okay, let there be misappropriation, whatever.
Right.
The fact is that can a FPS license be suspended for more than 90 days without so cause?
Lordship, that is order is, my lord, says no. Distribution order 90 days, it says no. After 90,
Then-
90, within 90 days. But since this is the case relating to my lord, that, now my lord, investigation is on, my lord, and the case is pending. So it means my lord, again, restore, because now the distribution is done by my lord, other fair fraction.
No, just a minute.
But
The question is more with the law.
But-
Where does it say that just because someone is an accused, are they accused in the case, if they're accused, if they're accused, whether you can deny them, because they'll be charged under the IPC or what?
Yes.
Nothing is clear from here.
yes, but that is not clear.
What is the charge against them? I don't know. What is the offense they have
Yes,
committed?
Lordship,
Page
FIR.
30,
33.
page 30.
Lordship,
No, that is,
page 34, Lordship, under section, my lord,
Kindly, the page,
page 30,
page 32. Then get to
PC Act.
please here. And my lord, 123, 420, 406, 409, related with section 13(1)(a), 13(2) of PCS.
No, this is IPC section, you are innocent until proven guilty.
My lord, this because of this public distribution, my lord. So they have not the delegation is my lord clear that all beneficiaries are not getting the my lord benefit. So
Then
they
why
were
don't
not
you
getting-
cancel the license?
my lord,
If that is your case,
allegation.
where is the allegation against them?
My lord, this, our affidavit only says, my lord, chief visitor, chief minister visitor, special visitor said case number 423 is pending, so that's why we have not taken any action. That is our affidavit.
Total.
there is nothing specifically against them. Is there anything specifically against them?
But, may I pay Malak method fix after application Malak in the meantime because I'll have to take whether regarding that Malak chief minister's special civil case, but if that case or Malak if it's the case because it's a existing matter. So, is there anything against them Malak? Because this respondent has not taken step because this proceeding is against them pending before the CM visit.
You have not filed affidavit.
I have
Yes,
filed
sir.
affidavit.
And what is your case? What is your case? Sir?
Paragraph 12.
Filed by respondent number 4.
No further from
Yes, ma'am. Yes, ma'am. Because of the pendency of the signature special visit.
So, tendency, but what is the specific allegation against that?
Yes, yes, Malak short, Malak.
But then this has been since July. Their shop has been suspended.
Not-
It is against the law. It is against your order, whatever Assam Public Distribution of Article Order 982. You had all the time in the world. Nothing remains. Okay, so today is the third day.
Malak, yes, on 15/5 notice was issued, Malak. And the last date I have filed on affidavit, Malak.
You have already filed an affidavit.
My-
Now what
I
more?
filed.
Now what more can you file?
But it's
There's nothing else. I think.
this is my, because of the pendency of this.
Right.
signature
Heard
special-
Mr. S.K. Roy, Land Counsel for the petitioner. Also heard Ms. Hugh Das, Land Counsel for
the response.
all the response. The petitioners are aggrieved with the order dated 7/7/20. By which the fair price shops operated by the petitioners have been suspended on account of they having been under judicial custody in connection with the Chief Minister's Special Vigilance Cell case number 4/2023. Where is your bail order is here or not? Bail order is here. The petitioners counsel submits next para that the petitioners were arrested in connection with the above CM Special Vigilance Cell case number 4/2020 and subsequently released on bail by an order dated 3/8/23 passed by special judge PC Act. Is it PC Act or what? Huh? Let me see the order. Where? Which page?
page 39.
Where is the certified copy of the order?
This is certificate.
This is certified by you. Where is the original? This is certified by you. See, when the certified copy is issued, we know who is the issuing authority, everything is there. Where is it?
There is that,
Special judge, comma, assam, comma, God. The petitioner counsel submit that though the petitioners have submitted an application to the respondent on 3/10/23 for revocation of their suspension order, the same has not been suspended till date. The learned counsel submits that in terms of section 15(2) for the assigned public distribution of articles order, 1982, hereinafter referred to as the 1982 order, comma. A license cannot be suspended for a period exceeding 90 days, comma, without giving an opportunity to the licensee for stating his case. He submits that the petitioners have till date not been given any show cause notice or an opportunity to for stating their case pursuant to section 15 is section or order? It's the order. No, order 15(2) of the 1982 order. We accordingly submit that the suspension order should be set aside. Ms. Yudas, the learned counsel for the respondent, submit what?
My lord, that, page 77, you got to be fine, that the five numbers of the were suspended, they were under judicial custody related to CM special vigilance case number 4 of this fact of high case officer, which is submitted for the minister special vigilance, as of no further action has been taken. Against the fact.
Submits that the petitioner was submits that the license issued to the petitioners for the fair price shop was suspended as they were under judicial custody in relation to CM Special Vigilance Cell Case number 04/2023. While office order dated 7/7/20. He submits them. The matter is submitted before the CM Special Vigilance Cell. And as such, the responding authority cannot take action against petitioner.
Cannot, has
Huh?
not,
Has not taken any action against them. Has petitioner. So you have not taken a decision also to,
my lord,
that's it.
regarding their
Next para, you're right.
application, my lord,
I have heard the count for the part. Order 15(2). This is order 15 of the 1982 order states as follows. A perusal of order 15 shows that in contemplation of the proceedings of cancellation of a license a license can be suspended for a period not exceeding 90 days, without giving any opportunity to the licensee for stating it. Order 17 of the 1982 order provides that when a licensee has been convicted by a court of law or has contravened any of the order made under Section 3 of the Essential Commodities Act, the licensing authority shall, by order in writing, cancel the license, without giving an opportunity to the licensee for stating his case. But where does it talk about fair price shop? This order. Where does it talk about fair price shop license? Yes. Yes, yes. Yes, Ms. Yudas, anything new?
Just kindly. From the part of the
Yes,
L minus
Huh?
Wholesaler and retail.
where?
A,
A.
bulk,
Which order? Order 2, 3, 4, which one? Order 2. Yes,
L, L,
L.
it is wholesaler. Wholesaler and retail. Here the retail product,
Huh? Retailer.
here the retailer. Retailer is appointed leader, says any part or more of the such option identity card, extra credit, one six, extra retail.
Let us see that suspension order again. Page. Where is the suspension order? Yes, madam, where is the provision for fair price shop dealers, agents of? Where is the provision for suspending the fair price shop dealers, agents? Where is the provision?
That's clearly I haven't seen that.
Then how can you do something which is not provided in the in your rule? How do you what is the basis for issuing a fair price shop or appointing a fair price shop dealer? Where is it? Huh? Order 3.
licensing authority may
Like,
issue
may issue license from what, such profit leader. Areas of.
Correct, but out here you are a FT shop dealer. Okay, so you are a dealer. So fair price shop dealer.
Not even catch it.
Okay.
Okay, don't say fair price shop license, say fair price shop dealer. Very good. Okay, so whatever I said last. Uh, provide the next step, no? Finished, no? In the present case, it is an admitted fact that the respondents have not given the petitioners any opportunity for stating their case. Against the cancellation, no, against the suspension of their license as fair price shop dealers. Fair price shop dealers. No show cause notice has been issued by the respondents to the petitioner's case. In view of the above reasons, this court finds that the suspension of the petitioner's license as fair price shop dealers is not sustainable beyond 30 days, beyond 90 days in terms of order 15 brackets of the 90 days to order. So consequently, this order pertains to all of you, no? Consequently, the impugned order dated 7/7/2023 issued by the Deputy Director, Food, Civil Supplies, Consumer Affairs, is set aside. That's all. The petitioner should be allowed to continue their should be allowed to continue to operate their fair price shops
We can allocate.
as per the arrangement that was in place at the time of the suspension, prior to the suspension. So this is of course subject to the condition that no further proceedings are, no further, subject to the condition that no new or further proceedings are taken up against the petition. There is petition accordingly disposed. Subject to the condition that no new or further proceedings are taken up against the petition. So you can take.
if anything.
Yes,
my lord,
yes.
Yes, sir.
The petition is accordingly disposed. No affidavit, what to do? Who's appearing for the other side? Agriculture Department. Yes,
What is doing scientific economy?
Miss, what is the name?
See, Lord.
G. Bora, Learned Counsel for the Agriculture Department.
Sir.
Is granted 2 weeks time to file affidavit of position. This is a matter of school.
Application. All in the for
This is for what?
petitioner should have opted off a fully constructed market. And
Okay. Utility model is there. Yes, who is appearing?
For both, it might
on the last occasion, the applicant appearing
R. Bora.
for a call number 4 and 5, it appeared, but that is correct now. Wait for time to file.
The petitioner's counsel is present. The respondent number 4 and 5 has not filed any affidavit in terms of the last order dated 29/5/26. In the interest of justice, leave the matter again. After the vacation.
Both the matter.
Interim orders passed earlier can continue to the next.
Both accepted for
In both the cases.
both. My lord, you have already taken step.
When?
But what is subsequently, that's for official 1/6/2024.
Huh?
That's for official dated 1/6/2024. The notice was, presented there. But was the essence was given properly, though.
Look, Mr. Counsel, there is a Lavazima court order of 10th June. Today is 19th June. You have not taken steps.
But I'm not aware about that order. But
You have not
now I
taken,
will take steps. Within 2 days,
Mr.
NH court.
N.H. Borbuya, last counsel for the petitioner. Submit that he will take steps for service of notice upon the respondent number 4. Within 3 days, within 2 days. This is the matter after police.
Earlier, last financial year, proposal was submitted, but it was not considered for some reason. Now, fresh proposal has been presented. The chief engineer is processing it. Take some time, but here, they will be for the processing of that. Processing of 6/4/24 a proposal has been given. There are some issues regarding the applicable level. How they have to govern that.
6 lakhs.
6 lakhs, yeah. This posted up to 4 days, I will take the step.
Mr. B. Robert, learned counsel for the PWRD, has submitted a letter dated 18/6/2024 issued by the chief engineer, PWD Road. Wherein a fresh proposal is to be made for grant of, for sanction of rupees 6,10,98. As the earlier demand proposal had been returned by the government. He submits that a fresh proposal is under process and will be submitted within
Possible give a matter after later.
within 2 weeks. It is the matter on, give it.
Also, after.
Give it.
Also, after.
Why?
Right.
That is, that's really 5 days, I think. Yes, 12:56, are you sure? You come to page, you come to para 8 of your petition. Application. Yes. How much is the days there? Why is it marked in white and then superimposed over it 30569? Even here. Who has done this? No, no initial. All the. Anyway, madam, the issue is the stand on the other side is that the order has been complied with.
I would not say
No. So has the order been complied with?
no, because it's not because because accepted the meeting before the everything. So I was you was given an opportunity.
So you mean to say what has been recorded by the court is wrong? No, it has to be. If you say it's right, then you've got no case.
Is that because before the everything. And
Madam, that's not. You see, I'm not one who beats around the bush. Give me the contempt case. You see, the contempt case, the last order is like this. Heard Mr. S. Khoun, learned counsel appearing for the respondent contemner, who submits that the direction passed in so dated so was complied with. Has it been complied with? So what has been recorded is wrong. That's why they have made a wrong submission according to. Madam, first you see, I do not know why you want to open it and have. Why don't you ask your client today whether the direction passed in the writ petition has been complied with? Why don't you ask now? That is what I'm saying. So that means this order that has been recorded, it was made on the basis of a wrong submission.
By way of like for response to the unfortunate so that's so non-profiting that catered to the mitigate the pain of cancer patients. The government something that they
Yeah. You see, what is the order of the court? What was the order of the court?
that the representation may considered by the deputy.
So has that representation been considered by the deputy commissioner?
The
Look, whether you were absent or not absent, that is not the issue. I am asking you the question, whether has the representation been decided?
it's not in favor of the
No, not in favor of the petitioner.
therefore created because that's
Where's the question? Where does the court say that you should be heard?
catered to
If the representation dated so and so has not yet been disposed of, then the respondent number 2 will take steps for disposal of the same within 2 weeks from the date of receipt of a certified copy of this order to be furnished by the petitioner. Yes? And after that, the representation was disposed of. What remains? You still agree, then you see, you can challenge that decision made by the respondent number 2 by way of a fresh writ petition. No need of liberty. Liberty is already there. Time to that is a different thing. This has been disposed of probably the order of 2017, probably 2017 itself. The decision was given by the deputy commissioner. Now you want to challenge that. That's a separate cause of action. You cannot now, in the guise of trying to open up a decision based on the order of the court, say that there's a delay in fee for restoration. There's nothing here. No liberty is required. You file a writ petition. No liberty is required. But you give, what you can do is you can dedicate two whole pages for explaining the delay in coming to court. You've got to give your reason for coming to court. This will not work. Right. Heard Miss S. Chakrabarti, learned counsel for the applicant. This is in 2393, yeah? 2393. And who's for the other side? No one. Who submits, on the comma, who submits that the delay of 257 days in filing the application for restoration of contempt case number 375 of 2017 should be allowed. Next paragraph. The applicant's counsel submit that contempt case number 375 of 2017 had been initiated by the petitioner, has been initiated by the applicant in view of the respondent number 2 not having complied with the order dated 7/6/2017 passed by this court in WPC 2426/2013. Next paragraph. The order dated 7/6/2017 passed in 2426/2013 states as follows. Page 18, I'll just read out. States as follows. This writ petition is, therefore, disposed of by granting liberty to the petitioner to approach the respondent number 2 seeking redressal of its grievance. If the representation dated 19/04/2017 bracket annexure dash Roman 4 bracket close has not yet been disposed of, then the respondent number 2 will take steps for disposal of the same within 2 weeks from the date of receipt of a certified copy of this order to be furnished by the petitioner. The writ petition is disposed of. In word commas close. This is page 18 of the contempt. Thereafter, contempt case C number 375 of 2013 was disposed of due to the submission made by the counsel appearing for the respondent/contemnor, who stated that the direction passed in WPC number 24226/2017 had been complied with. Let's just read one thing, that last sentence. This is disposed of by order dated 1/8/2008. Next paragraph. The order dated 1/8/2018 disposing of contempt C number 375 2017 is reproduced herein below as follows. The last order. I'll read it out. Heard Miss S. Count, learned counsel appearing for the respondent slash contemner, who submits that the direction passed in WPC number 2426/2017, dated 7/6/2017, was complied, but the learned counsel for the petitioner is absent. Full stop. Next para. Accordingly, keeping in view of the submission of the learned counsel for the contemner, this contempt petition is closed. Full stop. Next para. As the contempt petition should close on the submission made by the counsel for the respondent, and in the absence of the petitioner, applicant, the applicant file IA bracket C number 2392 of 2019, praying for praying that the order dated 1/8/2018, passed in contempt case number 375/2017, should be recalled and the contempt case should be restored. However, as there was a delay of 257 days in filing the restoration application, that is IAC number 2392 of 2019, the present application has been filed for condoning the delay of 257 days. To a pointed query made to the counsel for the applicant as to whether the Deputy Commissioner Kamrup M had disposed of the petitioner's representation, the applicant's representation dated 19/4/2017, in terms of the order dated 7/6/2017, passed in WPC number 2426/2017, the counsel for the applicant submits that the said representation has been disposed of. However, the applicant was not heard by the Deputy Commissioner Kamrup M, as the petitioner was absent from the office of the Deputy Commissioner at the time disposal of the petitioner's representation was made due to ill health. Have you got the decision? You have got the decision of the Deputy Commissioner? Oh, where is that? If there is a Deputy Commissioner's response in the contempt case, where is that? No, where is that? Acha, it is this is order dated 6 September 2017. Lengthy order. Only that you were not heard. Mustafa. The representation of the petitioner's representation was disposed of by order dated 6/9/2017 by the Deputy Commissioner Kamrup M, and the same is also a part of the affidavit filed by the Deputy Commissioner on 8/3/2018 in contempt case C number 375 of 2000. The only grievance of the applicant is that the applicant has not been heard at the time of disposal of the applicant's representation. Next paragraph. On considering the above facts, this court finds that the direction passed by this court to consider the applicant's representation by order dated 7/6/2017 passed in WPC 2426 of 2017 has been complied with. As such, there is no requirement of restoring the contempt petition as the directions passed by this court has been complied. Consequently, this court, consequently, the application for condoning the delay of 257 days is, no, before that, you're right. If the applicant was aggrieved with the order of the Deputy Commissioner, the same being fresh cause of action, the petitioner could have, if the petitioner had the liberty to challenge the same by way of a fresh proceeding. However, the same has not been done by the petitioner. And the manner in which the applicant, not petitioner, applicant is trying to revive a dead horse cannot be allowed. The application is accordingly dismissed. The application for condoning the delay of 257 days is accordingly dismissed. Then you write, in the other I, in view of the order passed in view of the order dated 19/6/24 passed in IA in 2393 of 2019, the present application for restoring the contempt petition is also accordingly dismissed. Madam, you have everything there. You can file a writ. You can say that this order has been filed, this order has been issued without hearing me. But then the direction passed by this court nowhere stated that you should be heard. You could have done it. No, I leave it up to you. Okay, take this. Non-payment of protective bill.
Pilot here.
Yes, for
I'm for NHADCL and ACIDCL.
that is the foreign number.
That's one number 2 and 4. He is asking direction from 2 and 6 to pay the amount. Where
2 and 6.
2 and 6. 2 means me and the contractor from where he is a subcontractor to reference number 6 without. Even 6 is no, he is not contractor with us. No agreement, nothing with us. Or he is doing 6 is just not contractor with us.
Okay, he's asking for payment from respondent number 6.
So he is demanding money all along. He is demanding from petition his apartments all along from 6.
Yes.
So number 6, that
Yes.
private contract from where he has got contract, subcontract.
Yes.
But direction he is seeking in ultimate para, nowhere is mentioning any two against 2. 2 and 6 direction is such that NSA should pay. Whereas he is not out there, he is not our even
He's not your contractor.
contractor, not even subcontractor.
He's not even your subcontractor.
Because that from whom he has taken,
That's
he
another
is
subject.
not contractor with us.
Respondent number 6 is a subcontractor of somebody else.
Somebody else from five.
For 5.
From
He is subcontractor of 5.
I was a contractor of five. Now he has taken from six. This is only because of this road is being not constructed. And still road is in bad condition. Matlab this is there is a deteriorate condition.
When you go
Only
to
because
civil
of
courts, the civil court,
This case is covered by our High Court judgment on order dated 12/6/2020.
no, you tell me what's your case.
Lordship, I am the subcontractor.
So?
But as
You have got contract, your contract is with whom?
actually, I responded no five contact with the NHDCF.
So?
Respondent number 6 contact with the respondent number 5.
Then,
Then thereafter, respondent number 6 handed over his subcontract to the petitioner.
Ah. Ah.
Which is the case. I have
Ah.
already completed the work.
you have completed the work. So your claim is against respondent number 5. I mean respondent number 6.
This case is, my lord, I was in this case also. This case is something else. Not from.
Let me see.
It is a green decker case. And this appeal is going on. Second case appeal is pending. State appeal. That case was, this case is direct link from contractor to subcontractor.
No, Lord, they've already mentioned the order, judgment and order that it is.
If he's taking,
Then I
my lord,
subcontractor.
if he's taking, my learned friend is taking support of this case, today's submission is that again this state appeal is pending. As on that.
Already contacted section 70 is.
Just a minute, just a minute. Is there any provision for consideration of payments to be made by the contractor to the subcontractor in your contract agreement between you and the respondent number 6? Is there any provision with regard to payments to be made from contractor to subcontractor?
As per affidavit in proposed.
Not as per affidavit, Mr. Counsel, as per the agreement executed between you and the respondent number 6.
Yes, Lord.
Is there any contract agreement, any clause in your contract agreement regarding how payments are to be made? Is it to come from the contractor or from the subcontractor?
For NHS, Lord, as per contract at Lordship 70 is already clear. The obligation of person enjoying benefit non-getting tax law.
You're not understanding the question at all.
Lordship kindly see Annex 1 affidavit in opposition law. Obligation of.
Just a minute, I cannot read. I'm reading your judgment. I'm reading this. Just a minute.
You show your liability.
You see, Mr. Kaushik, you have a contract agreement with the respondent number 6, correct? Where is it?
Lordship, annexure lordship. Annexure C lord.
C.
2024.
24.
Deed of agreement.
Yeah, what is your name?
My name is Ranjit Dutta.
Okay, RP Technique.
Technical.
Whereas there was a verbal agreement between the first and second party. Verbal agreement. Some sort of amount. To say,
Repeat number also.
So it is an agreement between you two.
If it's not.
They were never in the picture. It's between you and the respondent number 6.
Lordship already I mentioned, Lordship Gardenia Infra LLC is the responsible.
Okay. So you file a case against respondent number 6. That's all.
I have also made in party lot in the read.
But then who are you cannot file a case against him. He has got nothing to do with it.
If I'm out, Milord, let's go for private.
Huh?
If I'm out, let's go for civil dispute. In event it is perfect.
Yeah, for the respondent number.
2 and 6, 4.
Yeah,
We are
two and,
we-
yeah, for whom? 6
National
or
Highway-
4 or 2 or who?
National Highway Infrastructure Development Corporation Limited. That is, we are the constructing agent, matlab central government,
You are for 2 and 4.
2 and 4.
Who is for 6?
6 is the
6 is a private contractor. Sorry, 2 and 4 mean. 2 and 4. 6 is private.
Gardenia Infra.
With whom he was doing, and he got some amount from them, 4 lakh something. Remaining amount is due from him. It is from restaurant number 6. Restaurant number 6 is taken protect from restaurant number 5.
That he is doing with respondent number 5 so what? But there's nothing in their agreement which shows that he can have any claim with regard to the claim of the respondent number 6 from NHIDCF. There's nothing there.
Okay.
There's nothing
No,
connecting.
I have agreement with the respondent number 6 only for allotment of the works.
Correct.
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 I have completed the state work.
Correct.
Thereafter, he did not give the, paid the money.
Correct. Now what to do?
Lordship National Highway is also responsible, Lordship.
Sorry. How? They were not a party to your agreement.
Already our High Court judgment is already clear.
Your High Court judgment is not on this point. It's on a different issue.
Yeah, issue, Lord. You also not paid the 11 crore losses to insurance.
Respondent number 6 is not here, 5 is not here.
5 is here, Lord.
No?
Question Corbian loss is here.
Huh?
Judgment loss.
Huh?
It is judgment loss.
He is not understanding anything.
5 and 6 is not a case, Lord.
You'll keep on fighting and nothing will happen. Anyway, right. Mister, what is your name? PK, go appear for the petitioner. Mr.
See, good one.
appears for respondent number 2 and 4.
Lordship,
Yes. Oh, you're
maybe,
there. You're
Lordship,
for
I am
whom?
appearing, yes, I am for respondent number 7. CBI was made a party respondent in this case, Lordship. I don't know, Lordship. They are seeking.
CBI made a
seeking,
party for what?
CBI.
Yes, Lord. I have made
I don't know.
party, Lord. I have filed a FIR before the anti-corruption department, Lord. Therefore, yeah. Making party.
Yes, what have you got to say?
No, Lordship, I have nothing to say, Lordship. I don't know why,
What is
Lordship.
there to
They
say?
filed
Not
an
here.
FIR. I have nothing to say, Lordship.
This is a civil dispute. You cannot have a civil and criminal dispute. Two
Together.
issues going on in the same thing.
The private dispute will be settled by the GPA.
You to
Has
all
to
payments,
go for-
Lord, if you
CBI has
non
to go
payment
for
of the 30 lakhs.
Why shouldn't I dismiss your case right now?
Not to give a direction to the CBI to register a FIR.
He does not understand anything. There's no point trying to listen to you. You're not understanding a word of what's going on.
That is why it is gonna have filed.
Okay, right, right. Yeah, I've heard you. Mister?
Okay.
No. What is your name? M. Haloy. Appeals for the
Yes, I'm,
respondent
I'm
number
Haloy.
7. The
7.
CBI.
Yes, Lordship.
Respondent
Lordship.
CBI. Full stop.
Lordship.
As per the Lawazima Court order dated 7/6/2024, the petitioner has been granted several opportunities to provide information regarding the present address of the respondent number 5, but the petitioner has persistently failed to provide the same. Full stop. The petitioner is accordingly directed to provide the correct address of the respondent number 5 as a last chance by the next court date. Full stop. Further, the petitioner shall take fresh steps for service of notice upon the respondent number 6 by a registered post with AD within 3 days. Full stop. The petitioner's case is that the NHIDCL had selected the respondent number 5 as a contractor for doing the contract work. The respondent number 5 subcontracted a part of the work to the respondent number 6. The respondent number 6 again subcontracted a part of the work to the petitioner. Full stop. The agreements made between the petitioner and the respondent number 6 does not indicate anywhere that the petitioner would have any say in the bills to be made in respect of the respondent number 6, and neither does the agreement show that the respondent number 5 was aware of any subcontract made between the respondent number 5 and 6. 6 and 7. No, 5 and 6. 5 and 6. Full stop. The petitioner has also made the CBI as a party for recovery of his alleged dues from the respondent number 6. List the matter after 6 weeks.
Lordship. Highly of Lordship. Lordship, I could not appear physically due to illness, Lordship. I'm sorry for that, Lordship. I could not appear before your Lordship. I could not appear before your Lordship because of my injuries. I sustained some
Oh, what
injuries in
happened?
my hand.
What happened?
I just slept down in my bathroom, Lordship.
Oh
Got
my
some
God.
injury in both my hands.
Oh my God.
Lordship.
my
It is
God.
under plaster. That's
Oh.
it. Difficult.
My God, how did the bathroom? You've got to be careful. Okay.
Yeah,
Okay,
right,
take care.
Lordship.
Take care.
Lordship. Thank you, Lordship. Highly obliged. Highly obliged.
Okay. This matter, we have to pay some dues of it. So because of financial transfers, we are, the veterinary department is unable to pay in time. We have, we are committed to pay losses, but we need some more time. Losses, we have a soft with,
How much have you got to pay?
we use amount losses.
How much?
We told losses. Okay, so we have written for supplementary demand loss has been. That will be taken care of in losses. September. This is also a case losses, but similar to that one losses. Earlier one, some contact was there, but still losses. We are committed to pay because we have received.
Actual merits now, but might have come to page 31 for a moment.
No, I'm not on that. They have agreed that.
We have agreed to pay losses.
Have agreed to pay. Oh,
31 for a moment. I just need to page 31. The second last time.
yes.
Government is therefore requested to take necessary steps for payment of 75 lakhs at the earliest. Further, the remaining 3 crores odd. Only budget provision may be made for the next financial year 23-24. So 23-24 already passed. Now, next financial year. And the submission made by Learned said that there is lack of funds. There's judgment on there cannot be a ground in contempt proceeding. There is lack of funds. There's a direction of this Honorable High Court that has to come. With all due respect, my friend, may I kindly submit? Document give a long date, maybe after the decision. But by then, this is
It has to be after vacation.
in any case, let's say we have, if there are no strict orders, it would never come. One financial year has passed.
It is not there.
If it is
There
not
was
complied,
objection from the finance department losses, we have to clear it.
if it is not complied by the next week, at least personal affairs will be. That would do, madam. One financial year is already passed.
Okay, because of the subcontract part losses, we never brought it before this honorable court.
Well, you see, that is your problem.
Not it.
Now
Not
you
the
see,
contemplation.
you cannot
Not it.
say
We cannot
because
go.
I have been so understanding.
Not it.
You have got to be
Yes,
more
sir.
understanding.
Exactly.
But that is not the way this court functions.
Not it.
Once you have admitted your liability,
I have admitted.
then you have got to pay.
But because of that lordship, finance needs some clarifications. Lordship.
When was the contract completed?
Way back. They had supplied.
No, when was the contract completed?
Lordship, that 75 lakhs was already paid. Lordship.
25 lakhs paid.
April 19 to June 20th. Various.
So 75 lakhs paid.
That was paid.
When are you going to pay the rest?
Lordship in September this year. Because they have to go for. Lordship, when it is used amount, lordship, veterinary department do not get all the money. Lordship,
You're not even paying me in installments. You pay me installments, then you're not getting in one lump sum.
They were supposed to take budgetary provisions the last financial.
You pay me at least 2 crores now.
Lordship, I have to take some.
You pay him 2 crores by July.
I'll be satisfied with that. If that is done.
Also, I will take my instruction. I will try my best. I did not work with this. I will talk to them also, so that at least 2 crore may be taken. But I don't make a commitment today also because I do not have the instruction. But I make a commitment to that court, to this honorable court, that I will talk to them.
Because if you can't, you see, you rightly said, lump sum is slightly difficult. For government, because they are having governments having difficulties, they usually have. So small sums can be given you. Mr. Jivara,
M. Bhagwati.
I am Bhagwati, Land Council for the
For respondent number, lordship, 1 and 2, lordship.
1 and 2, submit that. The government will pay the amount due to the petition. However, as the amount is a huge amount, the government needs some more time. Respondents need some more time to pay the amount. He submits that he would obtain instruction as to whether rupees 2 crores can be paid to the petitioner by July 2024. This is the matter. No, you will July and
I'm very grateful. Part of.
After registered, I am appearing for assistance for 5.
Huh?
Which time will the capital of 5? After registration,
item.
30.
They come up to it, after it. All the
Okay, you want how much time?
Which type of?
Miss R. Devi appearing for the respond number.
5.
5 is granted 2 weeks time to file affidavit in opposition. This is the matter after speaking
for admission.
for admission. That's all. What is it? Oh, that process CBI case.